Good morning, and welcome to the, I think I've got a little echo there. Good morning, and welcome to the Hillsborough County Board of County Commissioners Land Use Meeting. Will everybody please rise for the Pledge of Allegiance, which will be followed by an invocation given by our chaplain, Commissioner Stacy White.
Thank you, Madam Vice Chair. We'll begin with the Pledge of Allegiance. Attention, salute, pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Heavenly Father, we will be making decisions this morning on a finite resource. It's important that we get these decisions right and balance that of the private property rights of the landowner, but also the neighbors that live in the community and even people that will live in this community that might not even be born yet. Father, we also want to pray for our first responders and members of our armed forces. Pray that you'll keep them safe each and every day and guide them. And we ask for these blessings and guidance in your heavenly name. Amen.
And now we'll have a roll call.
Overman, Cohen,
Here.
Hagan,
Here.
Kemp,
Here.
Myers,
Here.
Smith,
Here.
White.
Here.
You have a quorum.
Thank you. And I'll now recognize Mr. Brian Grady of the Development Services Department to inform us about the withdrawals, continuances, and remands.
Good morning, Commissioners. For the record, Brian Grady, Hillsborough County Development Services Department. Before we go through the published withdrawals, continuances, and remands, beginning on page 3 of the agenda, we do have a number of changes and addendums to the published agenda, so I'll go through those first. The first is on agenda page 6, item B1. This is major mod application 22-0452. The applicant is requesting to modify condition 13B as follows. Basically to modify the requirement for a 5-foot sidewalk along the project frontage to change that to a 10-foot wide multi-purpose pathway along the project frontage. The second change is on page 12 of the agenda, item C1, application vacating petition B21-0014. Staff is requesting this item be continued to the August 25th, 2002 Board of County Commissioners Land Use Meeting at 9 a.m. The next change is on page 13, item E2. This is application PRS 22-0939. There's additional parties of records that have been added to the backup. Next change is on page 14 of the agenda, item E6, application CD 22-06661, which is a petition to expand the Sherwood Manor Community Development District. The changes are correcting some typos in reference to a different CDD, so the corrections are to correctly reference the Sherwood Manor Community Development District within the background section of the report. The next change is on page 17 of the agenda, item F6, application rezoning standard 22-0699. The applicant is Bricker-Meyer Law Group. The applicant is requesting this item be continued to the to the August 25th, 2022 Board of County Commissioners Land Use Meeting.
Thank you. Was that it? Yeah. Thank you. And I just want to note that I want to recognize the applicant of item B1 and say that I very much appreciate their willingness to work with staff even up to the very last minute in providing additional bicycle, pedestrian safety infrastructure and provision, and that is very much appreciated even at this time. So thank you very much. Looking for a motion to approve the changes.
So moved. Second.
And we'll take a roll call vote.
Cohen,
Yes.
Hagan,
Yes.
Kemp,
Yes.
Myers,
Yes.
Smith,
Yes.
White.
Yes.
Motion carried 6-0.
Madam Vice Chair, who had the motion and the second on that?
Motion to approve was Commissioner Kemp and second by Commissioner Cohen.
Thank you.
And for the record, Commissioners, that was the additional bicycle trail, the multipurpose pathway was on Estuary Lakes Boulevard. So I'm really happy to see that on that constrained road. Okay, so now, do we do withdrawals now, or was that part of the changes?
Yes, we'll ask Mr. Grady to read through the withdrawals that are on the
Thank
part of
you.
the agenda. Thank you.
Mr. Grady, you're recognized.
Thank you. Next, I'll go through the withdrawals and continuances and remands in the published agenda beginning on page 3. The first item is item A1, Rezoning PD 18-0996. Staff is requesting this item be continued to the August 25th, 2022 Board of County Commissioners Land Use Meeting at 9 a.m. Item A2, PRS 21-1153. This application is to be continued actually, that is not correct. This is being continued by the applicant to the October 11, 2022 Board of County Commissioners Land Use Meeting at 9 a.m. as a matter of right. Item A3, Rezoning PD 22-0441. This application has been withdrawn by the applicant. Item A4, PRS 22-0523. This application has been continued by the applicant as a matter of right to the August 25th, 2022 Board of County Commissioners Land Use Meeting at 9 a.m. Item A5, PRS 22-0657. This application is out of order to be heard and has been continued to the August 25th, 2022 Board of County Commissioners Land Use Meeting at 9 a.m. Item A6, Rezoning Standard 22-0697. This staff is requesting this item be continued to the August 25th, 2022 Board of County Commissioners Land Use Meeting at 9 a.m. Item A7, PRS 22-0730. This application is out of order to be heard and has been continued to the August 25th, 2022 Board of County Commissioners Land Use Meeting at 9 a.m. Item A8, PRS 22-0738. This staff is requesting this item be continued to the August 25th, 2022 Board of County Commissioners Land Use Meeting at 9 a.m. Item A9, PRS 22-0739. Staff is requesting this item be continued to the August 25th, 2022 Board of County Commissioners Land Use Meeting at 9 a.m. Item A10, PRS 22-0833. This application is out of order to be heard and is continued to the August 25th, 2022 Board of County Commissioners Land Use Meeting at 9 a.m. Item A11, PRS 22-0844. This application is continued by the applicant as a matter of right to the August 25th, 2022 Board of County Commissioners Land Use Meeting. Item A12, PRS 22-0937. This application is continued by the applicant as a matter of right to the August 25th, 2022 Board of County Commissioners Land Use Meeting at 9 a.m. Item A13, PRS 22-0938. This application is continued by the applicant as a matter of right to the August 25th, 2022 Board of County Commissioners Land Use Meeting at 9 a.m. Item A14, PRS 22-0940. This application is continued by the applicant as a matter of right to the August 25th, 2022 Board of County Commissioners Land Use Meeting at 9 a.m. And item A15, PRS 22-0941. This application is continued by the applicant as a matter of right to the August 25th, 2022 Board of County Commissioners Land Use Meeting at 9 a.m. That concludes all withdrawals and continuances.
Thank you, Mr. Grady.
Move approval.
Second.
Got a motion to approve by Commissioner Kemp, second by Commissioner Myers. We'll take a roll call vote on those changes or those withdrawals and continuances.
Overman.
They want you on the microphone.
Yes.
Cohen.
Yes.
Hagan.
Yes.
Kemp.
Yes.
Myers.
Yes.
Smith.
Yes,
White.
Yes.
Motion carried 7-0.
thank you. And I'm going to take us to the next item is consent agenda. Is Ryan-
Move the consent agenda.
Second.
We've got a motion to approve by Commissioner White, second by Commissioner Kemp. We'll take a roll call vote on that.
Overman.
Yes.
Cohen.
Yes.
Hagan.
Yes.
Kemp.
Yes.
Myers.
Yes.
Smith.
Yes,
White.
Yes.
Motion carried 7-0.
thank you. And so we had item C, the vacation, continued. So we will move to our E section of the agenda, the public hearing. And item E1 comes up first with Mr. Grady leading us through that.
Yes, again, for the record, Brian Grady, Hillsborough County Development Services. The first item on the agenda is item E1. It's PRS application 22-0850. The project is located at 19203 North Del Mabry Highway. It's a 0.39 acre parcel. It's in the Lutz area of the county. As shown in the aerial.
Excuse me, Mr. Grady, I'm not sure it was clear to the people. I did not notice that there are people here that wanted to speak to item C1, and we have granted the applicant's request to continue that. So I just want to make sure that anybody who is in person for item C1 over there understands that this item will be continued to, what's the date? August 25th?
At 9 a.m.
At 9 a.m. So just to make sure they understand. I'm sorry to interrupt you for that. Go ahead.
And Madam Chair, the oath. The oath.
Yes. So at this point, we want to swear in people. You know, you could just say so. Yeah.
If everyone taking testimony will please stand and raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated.
Again, the next item on the agenda is E1 PRS 22-0850. The parcel is located southeast of the corner of West Lutz Lake Fern Road and Del Mabry Highway, an existing commercial shopping plaza. The area in red is the area of the subject modification. It contains an existing bank that's approximately 3,000 square feet. The request is to increase the size of the building to 5,000 square feet by enclosing the drive-through areas of the bank to accommodate a medical office facility. So again, the request for this PRS modification is increase entitlements by 2,000 square feet. As part of the approval, the parcel is specifically being limited to the medical office, health practitioner's office as part of this request. Staff finds this approval subject to revised conditions, and we're available if you have any questions. Thank you.
Thank you. We'll have the applicant presentation. The applicant has 15 minutes.
The applicant does not appear to be in the audience. I'm not sure if they're online.
We do not have anyone signed up virtually for this.
Yep. If the applicant has not appeared, do we automatically continue it, or what do we do with this?
It's the board's discretion. Could continue it. It is a supported application. We do feel that the change being requested is appropriate for the area. It will result in a net reduction in trips from the existing bank use to the proposed medical office. Maybe what I'd suggest is if we could continue this to the end of the meeting, we could try to reach out to the applicant and find if maybe they're having some challenge connecting with this meeting.
I'll move to continue this item to the end of today's meeting.
Second.
Got a motion to continue by Commissioner White, second by Commissioner Kemp. Let's take a roll call
Just
vote.
one, is there anyone else present to speak to this?
Good question, but nobody has signed up.
Okay, I just wanted to make
Right.
sure.
Overman,
Yes.
Cohen,
Yes.
Hagan,
Yes.
Kemp,
Yes.
Myers.
Yes.
Smith,
Yes,
White.
Yes.
Motion carries 7-0.
thank you.
Good morning. Sorry for my delay and late attendance. My apologies. We'll move on to E2.
Yes, the next item is agenda item E2, PRS application 22-0939, the Acton South Shore Bay Club LLC and Dune Land, one sub LLC. The request is for a minor modification to the project to modify the operating hours of the general indoor recreational use. Michelle Heinrich will provide a brief overview of the requested changes related to this requested operating hour change.
Thank you. Ms. Heinrich.
Good morning, Michelle Heinrich, Development Services. This is a modification of PD 050210, as most recently modified by Major Mod 21-0417. The site is located within the Waimama community, south of State Road 64 and west of Westlake Road. The PD permits single-family residential uses as well as an outdoor use known as Crystal Lagoon or South Shore Bay Lagoon. The lagoon is presently permitted to operate from 10 a.m. to 8 p.m. and is open to the public as well as residents. General public users are required to make a reservation, and the amount is limited by the number of spaces in the visitor parking area. Parking lot staff also maintains a log of visitors with their name, car, make, model, and color, and visitors must display a visitor tag on their car. Today's request is to specify the currently approved hours of operation to be designated to the public and provide different operating hours, which would be from 10 a.m. to 11 p.m. for residents and their guests. The primary enforcement of these hours will be conducted by the lagoon's operating entity. In addition to the currently approved enforcement mechanisms, the applicant has offered additional measures to easily identify residents from the public and enforce compliance. Those include the use of a waterproof hand stamp and towing that will occur in the visitor parking lot once the visitor hours of operation have ended. The parking lot will include signage to notify visitors of the towing policy. Staff concurs with these additional measures and also does retain the right to enforce these conditions. It should be noted that Planning Commission staff has found this request inconsistent. However, Development Services staff recommends approval subject to proposed conditions. Thank you.
Thank you very much for your presentation. We have set aside 15 minutes for the applicant to make a presentation. Is the applicant present?
Good morning, Commissioners. Kami Corbett with the law firm of Hill, Ward, and Henderson, and I do have a brief presentation.
Thank you.
As Michelle indicated, this is the South Shore Bay community. Next slide. This is for the Crystal Lagoon. You have just seen this most recently in a major modification to the rezoning to allow the public to utilize this facility. This is an as-constructed picture. Next slide. And then you can see this in proximity to the existing residential. Next slide. The approval history of this is, as you may recall, originally there was a private recreational facility approved in the original PD back in 2005. We then sought an alcoholic beverage service approval through a special use permit in 2021 for residents only, and through that process received approval to operate until 11 p.m. for the residents. And then we did the major modification to the PD in 2021 to allow the public recreational use. And there was some confusion on the part of the applicant or the about whether or not those were public uses, public hours, or private hours. But then when we realized we went back through the special use approval for the public use in 2022, that the alcohol sales would have to be limited to the zoning lagoon operating hours that we had agreed to the 8 p.m. And so we're here before you this morning to request approval to extend those hours of operation back to the 11 p.m. for residents only. There are over 90 support letters in the record from the residents supporting this change. We have no letters of objection, and we have new conditions strengthening those enforcement mechanisms. And I think Michelle covered those well. Next slide. And those are, obviously, we are extending from 10 to 11 p.m. for residents only. General public visitors must receive the waterproof stamp on their hands upon entry. And then we're also required to tow any vehicles that are there on site after 8:30 p.m. And we have to add additional signage stating the hours of operation for residents and visitors. And we have signage with the lagoon operator identified and the towing company identified. Next slide. And that's in addition to all of these requirements that were already in the zoning to control the public use of the lagoon facility. And with that, we would respectfully request your approval this morning.
Thank you. And is that the end of the applicant's presentation? There's additional time available if you have other parties. I have Ryan McCaffrey was signed up in person.
He is here with me, but unless you have any questions of him, he doesn't have anything further.
Okay, thank you. With that, we'll open it up for proponent testimony. There's 15 minutes set aside for any proponents. And I have two individuals that are signed up to speak as in support. That's Daryl Everett and Dawn Goins. And they are attending virtually, if I understand it correctly. Mr. Everett?
Here.
Oh, I'm sorry, Daryl. My apologies. Ms. Everett, you're recognized.
Hi, I'm Daryl Everett, and I live on Trite Bend Street in South Shore Bay. I'm here to speak in support of this application. Currently, we residents are paying a fee for amenities that we can only use when the public is able to use them. And that feels very unfair that we paid a fee to buy into the community. We were promised a community amenity, which the only amenity in the community that we could use for recreation is the lagoon, and we are only able to access it during those limited hours. Apartment complexes have later hours, and currently our lagoon closes before the sun goes down in the summer. So that feels unfair. We realize that there are public use, but we don't have access to it outside of public use. So we'd like to take advantage of that. We feel as residents that we have that we should have that right because we are paying fees into it. Thank you.
Thank you. Is Dawn Goins available on virtually?
Madam Chair, Dawn Goins did not sign into the meeting and she is not in the room.
Okay, thank you very much. Are there any other proponents interested in speaking? There's still 14 minutes remaining.
We do not have anyone virtually or in the room.
Okay, thank you very much. Any opponents available to speak to this item?
No one is standing up in the room.
Excellent, thank you very much. Then we will move to Development Services amended recommendations, if any.
No further comments at this time.
And then the applicant's rebuttal, if need be.
Cami Corbett, no. As you can see, this is something the residents want, and we would respectfully request that you approve this.
Excellent, thank you very much. I'm going to open it up for board discussion. Are there any comments or questions? Commissioner White, you're recognized.
Thank you very much, Madam Chair. This is clearly something that the residents want. I know it's not going to be easy for code enforcement to enforce this, but I think it's worth a shot. Any code enforcement issues would be complaint driven. So if in the event there ever is a complaint, I think we could, get bright minds together and figure out a way to, to enforce this, the provisions within this recommendation. So given that and given that this is something that the residents want so strongly, I'm going to move approval of the item.
We have a motion by Commissioner White and a second by Commissioner Myers. Commissioner Smith, you're recognized.
Thank you. I was just going to also wonder about how enforcement is going to work. I'm afraid the residents are biting off something that's going to be very difficult to determine who's a resident and who's not, and then for code enforcement to enforce this. But maybe Mr. Gormley could explain a little bit more.
Yes, ma'am. And board members, I'll tell you that we did coordinate with the Director of Code Enforcement on this. It is somewhat not typical of having this type of condition. We do feel that the requirements that are in place, the operational requirements, while somewhat manual, are things that we would be able to verify, particularly on a complaint basis, whether they are being done or not. And we do have the operator of the facility as the primary responsible party. There's a requirement in these conditions that signage be posted with a contact number. So if there's any uncertainty about whether it's being adhered to by the residents, there's an avenue to reach out, and we do feel that it is there are enough things in here that we can objectively enforce. Although again, recognize this is not our typical way of typical zoning condition, in that it's distinguishing amongst residents and not residents in the operating hours. And we did get some feedback from code enforcement that helped us craft these conditions as they are now, and I do feel that that we're able to ensure that they are not causing a problem with the community, and if something does come up, that we have responsible parties that we can identify to bring any type of action to bring it into compliance.
Thank you. And I agree with Commissioner White that it's clearly something that the residents very much want us to do. So I'll be supporting it.
Thank you for bringing that up. I have grave concerns about this. So if just to be clear, those individuals that have attended it during the day as public have been notified they have to leave by 8 p.m. Is that correct?
Yes. 8
And if they choose not to, they have their car towed.
Any cars that remain past 8:30 that have the visitor tag on them are subject to, it will be the operator's obligation to tow them, and it will also be the operator's obligation to ensure that all those visitors are identified, each individual when they come in, and that those individuals are identified when they go into the Crystal Lagoon to have the stamp placed on their hand.
Okay, so let's just deal with practicalities here. So a tow company is going to tow a car at 8:45 in that area. What is that person who missed the time going to do at 8:45 p.m.? And where is that car going to go? And how do they get there to retrieve their vehicle should they choose to make a mistake for whatever reason?
What our belief and understanding, and particularly by the commitment from the applicant, is that we'd hope that we do not have those situations. So the applicant has committed to enforcing these restrictions. So I think the towing is a sort of a backstop measure, but really we are placing the responsibility on the operator to ensure that those non-residents, visitors, have left the premises by 8 o'clock. So 8:30 is really a backstop for that. We're not looking at that as the primary enforcement action. We're looking at the operator of the facility through their business operations and identified individuals with the hand stamp of making sure that they leave by 8 o'clock.
Understood. Thank you very much. Can the applicant provide some guidance on the tow company that they've contracted and where they might store the vehicles that are being towed so that this now stranded person who's made a bad choice has got to figure out how to get to retrieve their vehicle at 8:30 in the evening?
Cami Corbett, for the record, if I could ask my client to come up and answer the question with respect to, they have, apparently they've contracted with several tow companies, and we have several on standby.
Excellent, thank you.
Morning. No. I'm not being sworn in. I'm Kartik Goyani.
Can you swear him in, please?
Yes, ma'am. Please stand and raise your right hand. Do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And if you could identify yourself for the record, please.
I'm Kartik Goyani with the applicant. To answer the question, the Homeowners Association and the Lagoon Operating Company have contracted with multiple towing companies as part of the standard operating process that are on standby if there is an issue. As our attorney stated, that's more of a backstop, but that is available in case that is needed. Thank you.
All right, thank you. I would just hope that there would be a proactive recommendation for those that would have their cars towed should they not choose to leave, be notified prior to having their car towed. I have lived in a community where tow companies have towed vehicles, and it causes great distress upon the person who has their car towed. It's enormously costly to have your car towed. And it is a very difficult thing to be stranded somewhere, especially when you're away from a metropolitan area. So I'm hoping that part of the process will be prior to having a vehicle towed, that the tow company would notify management that there are vehicles that will be towed, in order to avoid having someone get stranded in that area. But I appreciate the effort of the community to see something done and find a solution for the community. So with that, we'll take a vote. We have a motion and a second.
Overman,
Yes.
Cohen, Hagan,
Yes.
Kemp,
Yes.
Myers,
Yes.
Smith,
Yes.
White.
Yes.
Motion carried 6-0.
Excellent. Thank you very much. We'll move to E3.
Yes, the next item is E3, CDD 22-0551, with the petition to establish the Watershed South Community Development District. This petition has been submitted by NNP South LLC to establish the Watershed South CDD. The Watershed South CDD will encompass approximately 758.88 acres and located west of I-75 north of 19th Avenue Northwest, east of US 41, and south of Steak Tomato Road in the South Shore area east of Apollo Beach. No objections to the proposed CD were raised by reviewing agencies. Staff finds the application meets the requirements of Chapter 190 Florida statutes to establish a community development district and recommends approval. Board, you may recall this item was on the last land use meeting. As part of that application, the applicant identified 2 areas south of the area of the proposed CD. Basically, those 2 areas I pointed out that were identified as expansion areas. They were not included in the CDD, but per recent amendments to the state statutes regarding governing CDDs, they had identified them as future potential expansion areas that would allow a bifurcated review process in the future if they chose to include them in the CDD. The board raised concerns regarding those expansion areas as part of this establishment of the CDD, so continue the item. And in response to that, the applicant did remove those expansion areas from the request. Therefore, the requested CDD is, again, as noted on the graphic, with the no expansion areas identified. So any expansion areas in the future, if expanded, would have to come through the normal process and review before the Board of County Commissioners. The applicant is here if you have any questions, but indicated they do not plan on doing a presentation unless you have any questions. Thank you, and I'm available for any questions also.
Thank you, Mr. Grady. This is a public hearing, and we have set aside time for anyone that wishes to speak to this item. I do not have anyone signed up to speak on E3. However, is there anyone in the audience that wishes to do so?
No one in the audience.
Seeing none, I will close the public hearing and consider board discussion and a motion.
Move for
Commissioner
approval.
Smith?
Second.
Oh, okay. Move for approval by Commissioner Myers, a second by Commissioner Smith. Any discussion?
I just want to say I very much appreciate the applicant revising their application in light of the concerns we raised, and to note that I believe none of the following ones, E4, 5, or 6, are coming with that expansion request now, correct?
That's correct. None of them have that.
Thank you.
Excellent. Thank you very much. Please take a roll call vote.
Overman,
Yes.
Excuse me,
Cohen.
Commissioners? Commissioners, excuse
Yes.
me. The gentleman here has did you want to speak to this item?
No, not this item.
Oh.
Find out what happened with C1.
Oh, he's here for C1. We'll discuss that with him. We'll have staff speak to him about C1.
Okay,
Thank you.
well, we're bringing C1 back? Yeah, at the next meeting?
Yes.
Okay.
Yes. It was E1 that was moved to the end of the agenda. C1. was
C1
continued.
is,
Yes.
oh, right, exactly, okay. With that, please continue.
Overman,
Yes.
Cohen, Hagan,
Yes.
Kemp,
Yes.
Myers,
Yes.
Smith,
Yes.
White.
Yes.
Motion carried 6-0.
Excellent, thank you very much. On to E4.
Madam Chair, I'm a point of personal privilege before we move to E4,
Sure.
if I may. What's staff's recommendation on the speaker that's here for C1?
We will advise the speaker that the item has been continued. C1, there was some new information that was presented yesterday that needed some further vetting. To be able to
What should the speaker do? Will they be given an opportunity to speak today, or should they come to the county commission meeting that it's deferred to?
I'm sorry.
Your mic went off.
Sorry. They should come to the next month's meeting to speak to it, and we'll have staff speak to the gentleman right now and provide him particular information.
Fantastic. Okay, thank you.
Okay, where are we?
The next item then is agenda item E4. It's CDD's 22-0659, petition to expand the Balm Grove Community Development District. The petition is submitted by the Balm Grove CDD to expand the CDD by adding approximately 20.524 acres to the CDD. This revised CDD would encompass 288.196 acres and is generally located in the west and east side of Balm Wyoming Road, south of County Road 672 and north of State Road 674 in Balm. No objections to the CDD were raised by reviewing agencies. Staff finds the application meets the requirements of Chapter 190 Florida statutes to expand a community development district and recommends approval. We're available for questions. Thank you.
Thank you very much. We do have one person signed up as the applicant's team. That's Dana Collier. Does she need to be sworn in? And do I need to open the public hearing first before she speaks? Or he or she speaks?
Madam Chair, the applicant is here and has been sworn, but basically said they're available for comments and do not have a presentation unless the board has questions.
Okay, but I need to open the public hearing before the applicant speaks? After? Okay, great. Thank you very much. Please, you proceed.
Again, Commissioners, the applicant indicated they're here for comments, questions that the board has, but do not plan on giving a presentation.
Excellent. Thank you. Thank you very much. With that, this is a public hearing. We'll open it up for a public hearing and any comment by any persons that be interested in speaking to this item. Are there any persons that are interested in speaking to item CDD 220695? I mean, 0659.
No one in the audience.
Hearing none, we'll close the public hearing. Do I have any board discussion or consider a motion?
Move approval.
Motion by Commissioner White.
Second.
Second by Commissioner Kemp. And with that, seeing no discussion or hands raised, we'll take a vote, please.
Overman,
Yes.
Cohen, Hagan,
Yes.
Kemp,
Yes.
Myers,
Yes.
Smith,
Yes.
White.
Yes.
Motion carried 6-0.
Excellent, thank you. E5, sir.
The next item is item E5, CDD 22-0660. It's a petition to expand the Belmont Reserve Community Development District. The petition is submitted by the Belmont Reserve CDD to expand the CDD by adding approximately 6 acres to the CDD. The revised CDD would encompass approximately 193 acres and is generally located between Balm Riverview Road to the west and Balm Boyer Road to the east on the south side of Rodian Road in Riverview. No objections to the proposed CDD were raised by reviewing agencies. Staff finds the applicant meets the requirements of Chapter 190 Florida statutes to expand a community development district and recommends approval. Available for questions. Thank you.
Thank you very much. I see that Ms. Collier is available in person to answer any questions. Would you like to make a presentation?
She indicated she does not wish to give a presentation.
Excellent. Thank you very much. I'm going to open this up for a public hearing. Are there any persons that wish to speak on item CDD 220660?
There's no one in the audience.
Excellent. Thank you very much. I'll close the public hearing, open it up for board discussion. Commissioner Smith, you're recognized.
Thank you. And my concern with this particular CDD is asking, they're proposing to fund 63% of the CDD infrastructure with long-term bonds. That's more than 50%. That's a lot. And my concern is, the last one was 45%, the one next is 45%, and 63% is just tripping into the red danger zone for me. We have seen developments at the last boom where the CDD, the residents who moved in were left holding the bag because the developer had put all the infrastructure costs on them, pool, common area, mowing, roads, everything on them for long-term bonds. But what happens when there's a real estate decrease in the real estate market or even a bubble burst and you have a crash is you've had only like, half a dozen people move into a big development and they're left there. This area was in the New Yorker, was it? New Yorker magazine at the time of the last crash for these ghost towns that were left with just a few early residents who came in expecting the rest of the development to be sold and have a whole bunch of neighbors helping them with the cost. But no, the market crashed. So then they were there for years, just a few of them in this, ghost town with the developer just packs up their carpet bag and closes out their LLC and moves on. And these people are left having a few people are left having to fund the long-term bonds. So they're stuck with, pool not getting clean, mowing areas not getting mowed, roads still dirt roads in their neighborhood for years. I saw that at River Bend, for example. And as I say, there were several of them up and down 301. So, I'm not in a position to second guess the staff that is signing off on this today. I'm going to support this today. But I am saying this on the record to our staff and in order to ask them to please be very, very careful about vetting these and consider putting some kind of a cap on the amount of infrastructure that can be foisted on the CDD residents before they've even, before the developer has left. The developer has a majority interest in the CDD in the early stages and can outvote a handful of residents or whatever. But if the residents are left holding the bag for over 50% of the infrastructure, and then meanwhile, their house value is going down in an economic housing market adjustment or crash. And they can't, they have very few options. So I just want to ask our staff to be very, very careful about overextending the first people who move in and may be left holding the bag in these situations. We saw that happen here already. And that's my comment. Thank you.
Thank you. Commissioner Kemp, you're recognized.
Thank you. I've never had any of this pointed out before, nor understood it, nor dove into it as a matter of looking at it. I imagine it, I'm looking here at the numbers, a total of 15 million for about 63% is 9 million. The next one's 23 million, 45% for 10 million. So there's that also as a factor, but also probably the number of homes built. It sets my mind in a bunch of different directions about the math of how this works. But the main thought I had about this, I'd like to ask. I mean, what is the discretion on this? What for you all statutorily? This is, I just don't understand. I have very little knowledge of statutorily how this intersects with how these are set up, but we did see these disasters during the recession that were prompted by this HOA, CDD type of situation. So I'm wondering if there is discretion and what are the statutory, dictates in reviewing these.
Yes, I'll speak to that. Before that, I just want to note something about this particular application. This is an expansion of an already formed CDD. The expansion amounts to approximately 6 acres and estimated 20 single-family homes. The cost of the infrastructure to support those is estimated to be $1.4 million. of which 415,000 is proposed to be funded by bonds. So that 63% is an overall number for that would be the new expanded development. However, we probably should have set this out more clearly in the item for the expansion. It's 415,000 out of 1.4 million. So it's about a little less than a third for the expansion amount. So to the question of the statutory requirements, one of the findings that need to be made is whether a CDD is the best vehicle for financing the proposed infrastructure. So that's the statutory guidance that we have. There's not a numerical value attached to that. So we will take a look at that, take the board's comments here into play. It is something that we are cognizant of and sensitive to. If somebody were to come in and propose financing 100%, we have indicated that was not something that we were supportive of. So, where is that line, I think is the question, and we will come back, take a look at that, and provide the board with some additional information on that.
If I could just follow up, this is these kinds of petitions, these kinds of costs, are they done? I know it says common area infrastructure development. It'd be interesting to, understand exactly what that is. Is that roads and sewer, or and amenities, or is it limited to amenities, or what's included in that?
So the general description, there is not a breakdown of the amenity line, but it includes professional and permitting fees, environmental services, roads, water management control, water supply, sewer and wastewater, undergrounding of utility lines, telephone cable lines, landscaping, off-site improvements, and amenities. So it's a lot of the actual costs that go into developing the site. We don't have a specific breakdown of what that amenity cost would be.
So if this didn't come to us in this form of CDD to pay for this, let's say someone didn't use this financing mechanism for the development, a developer didn't use it, would this instead be at the start a cost on the housing, just increase the cost of a home?
I would just presume that would be the case. These are actual costs of development, and these are all requirements that these work be done. Roads, sewer, infrastructure, they are all things that are required to be done. There's a cost associated with them if they're not funded through CDD and developer contributions as being proposed here. There would need to be some other funding source, and would presume that cost is accounted for somewhere in their business plan if it were done differently.
It might also, so when someone buys a home in a CDD and they have their costs for their mortgage and they have their taxes estimated and insurance, do they also have a notice of how much it would be? I guess it's a monthly payment or a yearly payment that's done to the CDC, and do they have disclosure of what that could be? Because obviously what happened during the recession is that all of a sudden, maybe they thought, I'm just picking this out of the hat, but let's say it was an annual fee of $2,000 or something, that all of a sudden, because there were fewer houses and fewer developments, that they got instead received a bill for $9,000 or $20,000. How does, can you speak at all to how that works?
So the county's not involved with that county doesn't have a regulatory role in that, but there is a disclosure when somebody buys into a community that has a CDD, or if somebody's already a property owner, they have to consent to the formation of the CDD. So there is notice of that. I don't know whether they're given an estimated amount of the assessments, but those can change. So it's a matter of the cost that the CDDs bear. That's a function of the assessments. We know the upfront estimated construction cost here at the time of formation, but CDDs are also sometimes used as operational, many times used as an operational entity, and the cost of the operating costs are paid for by the members, the properties within the CDD.
Well, I have no further questions at this time. I was just interested at this particular moment in learning a little bit more, but I think it would be, at some time in the future, I don't know, we've dug rather deep on a lot of things, but not this, to understand if there's a role for the board to play and what that might be in being responsible about not having something like happen during the recession again. But I'll be supporting it at this time, and thank you for your answers. But I think, might be in the future, because this is governs so much of our housing here in Hillsborough County, and maybe like 99% of what we do now in terms of residential housing. So it might be it might be something we should be exploring further.
Sorry, Commissioner Myers, you're recognized.
Thank you, Madam Chair. I do feel that 63% is a high number, and I do support Commissioner Smith. If you make a motion for a cap, I think in staff come back, we might have to look at it an individual case-by-case basis, but a cap will certainly avoid for future being up 63%, and we're looking for homeowners to support that. Thank you.
Thank you.
Commissioner Smith, you're recognized.
Thank you. And so I'm hearing this one is a relatively small one with only 20 houses being added on, but the amount is $415,000. So somewhere in that inch-thick stack of papers that you sign when you buy a house, I'm presuming that there's a page that tells you you're also agreeing to take over your share of the $415,000 worth of infrastructure that is, in this expansion we're looking at today. And, so each one, if all the houses sold, would be taking out at the same time they bought their house a share in this $415,000 infrastructure to the tune of $20-something thousand each. But if the music stops in the market when only 2 people have bought in, then they're on the hook for the $415,000, all of them. Or, well, like what we saw, what got written up in the New Yorker magazine in 2009-ish, when we were ground zero for the housing crash. They can't afford to do that, so the infrastructure doesn't get built and the weeds grow up and they're living in a crazy ghost town. And so I do think, and thank you, Commissioner Myers, I think it's, and Kemp, I think it's worth maybe a workshop or a presentation at a future land use hearing about how this actually works, and maybe consideration of how or whether we need to protect the consumers and the home buyers in Hillsborough County with anything like a cap or to the percentage of the infrastructure they're responsible for, or a cap of the amount, or some at least really specific notice in terms of a graph of what happens if not everybody buys in over time. If it's because I'm thinking it's kind of like a condo association where, you know, whoever's in the condo is responsible for the common area costs. But, you know, if you have a lot of vacancies in that condo, your fewer people have a higher assessment. So maybe we could have a future workshop and kind of at least get a little bit more comfort and understanding of what it is we're doing and where the responsibility lies for protecting those consumers in our county.
Yes, and certainly I think that type of workshop would be helpful, and did want to emphasize that the statute does limit the role of local governments very severely. So something like establishing a cap on CDD infrastructure at the local level would be problematic. So certainly I do think we can work closely with staff and look at what we're evaluating in the process and bring back information if that's the board's pleasure, or hold a workshop.
I think that would be enormously helpful. I mean, my observations are, you know, it sounds as like, from what I think I understood Mr. Gormley to say, is that, you know, this CDD is broad in nature. Some of it's basic infrastructure for developing. And honestly, for the 400 and whatever it is, it's $20,000 per home. So rather than, you know, eat into the developer's profits for a basic infrastructure, not maintenance, or maybe some of it is maintenance of the amenities, but it's not clear, to me at least, how much of it is actual investment in building the community, and how much of it is a maintenance of amenities that are developed once the community is developed. And how that's financed, and where that CDD sits in the lien structure. You know, we have a problem with the PACE program because it sits in first lien position. And so we're not willing to actually finance that for a homeowner's maintenance, but we are willing to pass on the cost of a maintenance of a community. But in addition to that, we're passing on the cost of actually building the community, and not in the purchase price. So what that does is it allows the developer to have a lower cost to themselves, but to sell the house at a higher price and pass on the cost of the infrastructure. So I think it would be very helpful to understand where this financing mechanism fits. Because right now at low interest rates, it's very attractive. But should that financing mechanism have a floating rate or an interest rate that does float, it could become very unaffordable for the community to be able to pay for the infrastructure for a house they purchase, you know, in the next year or two, whenever this house is available for sale. So for the 20 homes in this project. So I'll support it, but I think there are some questions that we need to discern how we assure homeowners, you know, what their options are, and make sure that we're offering them a clarity on what their obligations are, especially when it's, as you said, you know, when you're signing and buying a home, depending on who the financier is and who the developer is, you know, you're signing a stack of papers that's, you know, 20 inches thick. And a document like this that has certain risks that fully need to be disclosed need to be fully understood. And so I'm not saying that they're not, but I think it is important that we make sure that they are. So with that, I'm not seeing any other comments. Do we need them?
Just a clarification, would the board like this to come as a report at a land use meeting, or like a separate workshop scheduled on the CDD?
A report at a land use.
Yeah, I don't think we need a separate workshop. We can add it to an agenda that might be short.
Yeah.
Thank you.
Thank you.
I thank you very much. With that, do we have a motion?
And when's that agenda, the short one?
We'll just check out the agendas and see when it can come back. Do I have a motion by Commissioner Myers and a second by, do I have a second?
Sure,
by Commissioner
I'll second.
Smith? Okay. And Kemp? Please take a roll call vote.
Overman,
Yes.
Cohen, Hagan,
Yes.
Kemp?
Yes.
Myers?
Yes.
Smith?
Yes.
White?
Yes.
Motion carried 6-0.
Thank you very much. Next item, please.
The next item is agenda item E6, CDD 22-0661. It's the petition to expand the Sherwood Manor Community Development District. The petition is submitted by the Sherwood Manor CDD to expand the CDD by adding approximately 45.77 acres to the CDD. The revised CDD would encompass 225.49 acres and is generally located between 6th Street Southeast and 15th Street Southeast and north of 21st Avenue Southeast in Ruskin. No objections to the proposed CDD were raised by reviewing agencies. Staff finds the application meets the requirements of Chapter 190 Florida statutes, expanded community development district, and recommends approval. As with the prior applications, the applicant is here if there's any questions, but does not propose to do a presentation unless the board has questions. Thank you.
Thank you very much. This is a public hearing. I will open it up for any comments or anyone that is interested to speaking to this item. Given the applicant has waived the presentation at this point and not seeing anyone signed up to speak to that, is there anyone in the audience?
There's no one in the audience.
Okay, excellent. Thank you very much. So I'll close the public hearing and open it up for board discussion and/or motion.
Move for approval.
Second.
A motion by Commissioner Myers, a second by Commissioner White. Please take a roll call vote.
Overman?
Yes.
Cohen? Hagan?
Yes.
Kemp?
Yes.
Myers?
Yes.
Smith?
Yes.
White?
Yes.
Motion carried 6-0.
Excellent. Thank you very much. Now we're on to section F, the regular agenda. Public meeting, which is limited to the Lujo record, where Mr. Grady.
The next item is agenda item F1 is rezoning application PD 18-0798. The applicant is Johnson Pope, Boker, Rupel, Burns LLP. The parcel is located at 108 North US Highway 41 at the southwest corner of West Shell Point Road and US 41 in Ruskin. The parcel is currently rezoned Ruskin Town Center 1. The applicant is proposing a rezoning to PD to allow the RTC 1 zoning district uses plus the motor vehicle sales, which is a prohibited use in RTC 1. The RTC 1 district is a traditional neighborhood type district with enhanced building placement designs and to provide for the provision of a town center as part of the Ruskin community plan. And again, auto-oriented uses such as motor vehicle sales are specifically prohibited within the district, and the applicant is again requesting to add that use to this parcel. It's an existing use in the parcel as shown by the aerial. The applicant is requesting a relief from certain sections of the Ruskin Town Center regulations in the Land Development Code concerning off-street parking and building frontage and building design. As you will see, staff is not supportive of this request. From a general compatibility with the proposed use, given the fact this is a prohibited use when the RTC 1, we're not supportive of introducing the use into the district, nor are we supportive of the relief from the design standards. Therefore, staff is not recommending support. It is also found inconsistent by the Planning Commission and recommend for denial by the Zoning Hearing Master. Staff's available if you have any questions. Thank you.
Thank you very much. Oral arguments are limited to the parties of record, and currently we'll open it up for the applicant to offer 10 minutes of testimony. Is the applicant present?
Good morning, Commissioners. My name is Mark Bentley, 401 East Jackson Street, Tampa 33602, and I represent the applicant. We're inclined to seeking a rezoning to PD to allow all uses authorized under the RTC zoning district, along with auto sales, which is a prohibited use under the RTC. The auto sales has been at the subject property in one shape or form since 1986. It's known as Ted's Auto Sales and Repair through 2012. In all respects, if approved, the proposed use would comply to the extent possible with the RTC design standards. I think if you pose the question to the staff, this would be the most RTC compliant redevelopment project in the history of the RTC, which was adopted in 2005, and that's in the record. So we would comply to the extent possible under the RTC. Notably, the RTC, when adopted, said any existing lawful use may remain, and it didn't say whether or not the use had to be principal or subordinate. Our client was advised that auto sales was a permitted use, lawful use of the property per the plain unambiguous terms of the code, and sales could continue accordingly in good faith reliance on the code. The client purchased the property. We are in disagreement with the county's interpretation of lawful use, but we've argued that point ad nauseum over the last few years, and we just want to move on here, and hopefully we can find a mutually beneficial solution that satisfies the county, the residents of Ruskin, and also our client's business. In any event, the zoning administrator confirmed that a use that is prohibited in the RTC, auto repair, was the principal lawful use at the subject property and could remain. Note that the auto repair does not have to comply with the RTC standards, but can remain its unsightly condition and never have to comply with the RTC in perpetuity. And why is that? Because there's a distinction between existing lawful use and a legal non-conforming use that would expire if not used for a specified period, or if there were an act of God that destroyed it by a certain percentage. So all the uses that you see in this area of US 41, you see pawn shops, auto repair, lawnmower sales and repair will be allowed to remain in perpetuity without complying with the RTC. I understand that a change of use may trigger compliance with the RTC requirements in terms of building location, things like that, landscaping. But this would require multiple variances or even filing a PD like this present situation to comply with the RTC, as buildings on US 41 certainly don't comply with the locational requirements in the RTC. And the only way they would be able to do this, as I mentioned, to be modified, they either have to be modified or demolished and reconstructed, or receive variances or PD rezoning to grant waivers from the RTC. Had the community been aware of the negative implications of the RTC, I suspect that it wouldn't have been so receptive when the county adopted the RTC requirement in 2005 that forced relocation of buildings and other requirements. The negative implications have stifled growth and redevelopment in the RTC, as exemplified by the lack of activity in the RTC in the 17-year history. Incredibly, the RTC in 17 years has no redevelopment project has complied with the RTC. As an example, at the northwest corner of Shell Point Road, US 41, directly across the street from the subject property, that was a real estate showroom that was converted to an attorney's office that didn't comply with the RTC. And also in 17 years concerning new construction, there have been only 2 businesses that have come into the RTC, and both of these businesses had to receive variances from the RTC to locate in the RTC district. These were the Family Dollar and an AutoZone, and I can give you the case numbers for the variances, but we're short on time. So as a condition of approval, our client would relinquish the vested right to auto repair, which is in high demand as a result of the prohibition under the RTC for auto repair and the limited opportunities. I have some photos here I'd like to show you. Can we switch now?
Excuse me, Mr. Bentley.
Yes, ma'am.
I just wanted to confirm that those were previously placed into the record or shown at the zoning hearing master hearing.
Yeah, we've had 3 zoning hearing master cases, and the record consists of about 900 pages, and all these, everything I'm showing you are telling you is in the record.
Thank you.
Sure. This is in the RTC. This is pawn pros. This is a prohibited use in the RTC that can remain there forever. It's an existing lawful use. Here's another auto repair down the street, the Marwin Auto Services. Likewise, that can remain. Here's the subject property, kind of the existing condition I'm pointing to right here. It's my client's business. Thank you. And if approved, this is what the client intends to do to comply with the RTC to the extent possible. You can see the change here with the canopies covering the cars, and we changed the access as well. Do I have to turn this back on? So notably, the senior zoning official advised the board at its October 9th, 2018 meeting that, and I quote, "In the PD proposal, the applicant from a design perspective doesn't significantly deviate from the RTC." And he goes on to say in the proposal that we meet the intent of the RTC. Then he concludes that the applicant has done a sufficient job of addressing the RTC design standards, but where the point of differences between the county and our position is the use, because the use is specifically prohibited in the RTC. Our client is a small businessman and employs about 10 people, mostly minorities. His clientele consists of mostly lower income, blue collar workers who purchase reliable transportation at a reasonable price. Our client also provides flexible financing and even as a service to the community, provides English lessons. Through his commitment to the community, he has established a very successful business, has become an integral part of the community. So our client is trying to remain at the property, if not permanently, then on an interim basis to allow him to relocate in the market area outside the RTC and maintain the customer base and goodwill that he's established over the years. So our client is proposing the following: to stay permanently, and if so, develop the property per the site plan that I just showed you. If the board is reluctant to do that, the client would request a 5-year period to transition off the property, to find new property in the market area, build a new facility, and then transition his business. In any event, after that occurred, any new development at the subject property would have to comply with the RTC to the extent possible, meaning that short of actually demolishing the building. He also agrees as a condition to relinquish his legal right to auto repair, so the community will be free from the potential unsightly auto repair, which is pretty prevalent on US 41, in which they are trying to eliminate. So if this is approved, you'd eliminate that and have a use and aesthetic that meets the RTC after the 5-year period. The client would also dedicate at no cost to the county 8 feet of right-of-way that's necessary for the widening of Shell Point west of US 41. He'd also provide cross-access to the property to the south and also cross-access to the property to the west, which is owned by Miss Sandy Council. Also, bear in mind that the subject property is on the very fringe of the RTC. It's not like in the heart. It's, you know, it's kind of, I won't say hidden, but it's one of the last properties before you get to the bridge, and it's on the fringe. And once you cross the bridge, auto sales is allowed. Okay, so it's really not out of character. And also note that even though there's a prohibition of auto sales, it is a CG use, and CG uses are allowed in the RTC, but for a handful on the list I first showed you. And there was testimony in the record that but for the RTC, that the auto sales would be compatible with the surrounding uses in the area. And that was an opinion rendered by Mr. Brian Grady at the ZHM. So here again, the preferred option is to stay there permanently and then comply with the RTC to the extent we can. I think staff would agree that short of demolishing the building, we've done everything we can to comply with the RTC. However, in the alternative, at least give the client 5 years to get off the property, and then up to 5 years. And if it's prior to that, then any development afterwards would have to comply completely with the RTC. Auto sales would be prohibited, and there would be no auto repair. So if you have any questions, I'll certainly attempt to answer them. Thank you.
Thank you. We have time set aside for oral arguments by proponents and opponents, parties of record regarding the hearing. The proponent testimony is set aside for 10 minutes. Are there any proponents that wish to speak to this item?
We do not have anyone online or in the room.
Okay, and then I have 2 individuals that have signed up virtually to speak as opponents. Do we, I'm going to recognize William Breadbenner. Is Mr. Breadbenner available?
William, you are muted. I'm going to unmute you.
Sandy Council will be speaking.
Okay. With that, I'll recognize Sandy Council. You have
Good
10
morning.
minutes.
Good morning. As president of the Ruskin Community Development Foundation, we want to go back on record again as supporting the staff recommendation as well as the hearing master's recommendation for denial. And by full disclosure, I am the adjoining property owner.
I'm sorry, excuse me. Ms. Council, can you turn your video on? Is that possible?
I'm trying. I'm working off of a different device that I've used to.
Ms. Council, if you go to the bottom of your WebEx session, there's a start video button.
And we've been pushing that, and it's not.
It's there, it's just.
Is it working now? I can go to another.
We can see you now.
There you are.
Okay.
Thank you.
Good morning. Thank you. Should I repeat what I just said then?
I don't believe you need to repeat it.
No, ma'am. Just please proceed. I'm sorry for the interruption, but.
No problem. So in other words, Ruskin Community Development Foundation, again, is going on record as denial.
You have 9 more minutes if you're interested, ma'am.
No.
Okay, thank you very much.
After so many years, I think we're all ready to end this.
Understood. I appreciate that. Are there any other individuals that either had previously testified on the opposition side? Present?
We do not have anyone else in the room.
Okay, great. Thank you very much. So we will offer the applicant an opportunity to rebut the testimony. You have 5 minutes.
Okay, just to back up here again is that what your code says. Go to the overhead. Here's the code that was adopted in 2005, and what I'll do is just point to the relevant section. It says existing lawful uses, lots, structures, etc., shall not be required to be removed or otherwise modified. So what we did is throughout this process, there are 13 documents that, including affidavits from customers, people who reside in the area, the owners of the subject property, who operated Ted's Auto Repair since 1986, and sales, that a use at the property was auto sales, but we've never asserted that it was a primary use or a car lot, but there are always auto sales conducted. And I think, commissioners, you're familiar with a lot of the smaller mom and pop kind of operations where they will do repairs and on the side they'll sell a few cars, okay? So as you can see here, it says existing lawful uses. It doesn't say it has to be the primary or subordinate or accessory. So that's kind of where the glitch came, and then our client bought the property, and this is kind of the long and winding road a few years later, and we're trying to get this resolved right now. So as I mentioned, he's established a very successful business. He wants to remain there. This would be the most compliant RTC redevelopment project in RTC's 17-year history. And that's also confirmed by staff in the record as well. So there's really not much more he could do to comply with the RTC but for demolish the building and relocate it per the RTC standards. So, and then in the alternative, I think it's reasonable based on the investment in the property, in the situation, circumstances, that if he could stay there 5 years. And one thing that's important too, when all this came down, the RTC, because it was an area-wide rezoning, specific notice didn't go out to the property owners. So each property owner wasn't really on notice of the change. And it's kind of hidden too, the changes in the code in terms of the prohibitions. You have to go several pages back into the code. And actually, I think the ordinance that adopted the RTC at the same time adopted the notice ASA overlay and maybe Riverview. So it was some massive land use changes, okay? And unless you were really in the trenches in tune with what was going on down in Riverview, that was a surprise to some of these property owners, is that this list of uses that are allowed in CG that were always allowed since zoning was adopted down in Ruskin all of a sudden became prohibited, and they didn't find out after the fact. And what happened is actually a lot of them, once they found out and became non-conforming, I think Commissioner Hagan was on the board at that time, is they came in, and if you look at the code, they specifically exempted by folio or their property certain uses once these property owners, got wind of the fact that they would be prohibited. Unfortunately, Ted Piatta, who owned the subject property, didn't realize ever when he was operating out there that motor vehicle sales or repairs were prohibited. So here again, the repair, I don't think the community wants another auto garage on that corner, but the client could freely do that, okay, and not make any changes to the property. But here again is a condition, and these are in the conditions that I provided staff. He would relinquish the opportunity or the ability to conduct auto repair of the subject property. So I really appreciate your time and consideration. If you have any questions, I'll try and answer them. Thank you.
Okay, thank you very much. Planning Commission staff?
Thank you. For the record, Melissa Leinhardt, Planning Commission staff. The subject property is located within the Office Commercial 20 future land use category. The site is in the urban service area and also located within the limits of the Ruskin Community Plan and the South Shore Area-Wide Systems Plan. The rezoning request is to change the Ruskin Town Center 1 or RTC zoning district to a planned development to recognize the existing motor vehicle sales business and allow other RTC 1 permitted uses. It should be noted that the site underwent a zoning verification in 2014, and it was determined by the Development Services Department that the site failed to establish that motor vehicle sales was an existing lawful use at the time of the establishment of the Ruskin Town Center 1 zoning district. Policy 9.2 of the future land use element states that the developments must meet or exceed land development regulations. As demonstrated on the site plan, the request does not meet the intent of this policy. The site is located within the limits of the Ruskin Community Plan and specifically within the Ruskin downtown area. There is specific language within the community plan of Goal 1 and 2 that express how development within the downtown should be designed. As the parking fronts the site and is a dominant portion of the site, it creates the look of strip commercial development. Objective 23 of the future land use element, as well as the Ruskin Community Plan, discourages strip commercial development. The second remand was granted by the Board of County Commissioners for the purpose of considering the Ruskin Community Plan profile. Planning Commission acknowledges that the Ruskin Community Plan profile was completed. However, due to the fact that this community plan profile is not adopted document, Planning Commission staff cannot use the document in their analysis and consistency findings. The applicant did attempt to make changes to address the design of the site to further the intent of the Ruskin Community Plan. Fences within the RTC1 area are to be made of masonry or vinyl or cast iron, and the applicant has agreed to remove the chain link fence that is currently on the site. The applicant is also providing additional screening and an awning above the cars along Shell Point Road and US Highway 41 to help reduce the appearance of the display of cars. Though the applicant is providing increased screening along the frontage of the site and also screening the waste storage and mechanical equipment, the proposed design of the site is still too much of a deviation from the Ruskin Community Plan, and therefore it is not consistent with the vision of that community plan. And based upon those considerations, Planning Commission staff finds the proposed plan development inconsistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County. Thank you.
Thank you very much. With that, we'll hear from the zoning hearing master recommendation summary.
The zoning hearing master considered the request for rezoning of just over a half an acre from the Ruskin Town Center 1 RTC1 designation to planned development for the purpose of recognizing the existing commercial building for auto vehicle sales for a limited period of 5 years only and to permit uses allowed under the RTC1 zoning district. The applicant's representative testified that if the planned development were approved, the existing auto repair use would cease operation. This request, as the ZHM explained, was remanded for a second time by the Board of County Commissioners on December 20th, 2019 at the applicant's request purpose of the remand was to provide for consideration of the Ruskin community profile. The applicant's representative filed a copy of the Ruskin community profile into the record. The Planning Commission staff stated that the Ruskin community profile is not an adopted document and cannot be used in their analysis regarding land use decisions. As you've heard, the Planning Commission staff does not support the request. Development Services Department staff testified at the zoning hearing master hearing that the modification to the request that the operation of the existing auto vehicle sales land use was to be allowed for only a period of 5 years does not change the staff position that auto sales is incompatible with the established development pattern in the area. The zoning hearing master found that the current request to allow only temporary use of the property for motor vehicle sales for a period of 5 years does not address the concern with the request being incompatible with the existing development pattern. The ZHM emphasized that the property owner has been aware of the prohibition on auto sales on site since the zoning interpretation was issued by the county in 2014. The zoning hearing master found that the rezoning to PD is inconsistent with the LDC and comprehensive plan, as the proposed motor vehicle sales use is incompatible with the existing development pattern. The rezoning request is also inconsistent with the Ruskin community plan, as motor vehicle sales is a specifically prohibited use in the Ruskin Town Center development regulations. The zoning hearing master therefore concluded with the recommendation of denial of the plan development rezoning request.
Thank you. With that, I'll open it up for board discussion. Commissioner Smith, you're recognized.
Thank you. Commissioners, as you know, I was very involved in writing the Ruskin Community Plan with the rest of the residents of Ruskin, many, many residents of Ruskin, and businesses and developers and their land use attorneys were in every meeting of those for 2 years. It was a very intensive process of signs all over the area letting people know what we were working on, and finally bringing something to the county commission that everybody agreed to: developers, landowners, residents, and everyone. Since then, we went through some efforts of implementing pieces of our community plan in the land development code. Again, very public workshops, community meetings, and coming to the board. As noted, this town center piece was approved in 2014 by the county. I drive by this intersection every day. The applicant has said something about it's on the fringes and shouldn't be in the middle. No, it's smack dab in the middle of our town center, as Melissa Leinhardt noted. This applicant has been slipping and sliding around all these code violations for years, violating the land development code for years by using delaying tactics. They knew when they finally would get here that they would get all these recommendations of denial because it's not compatible with the community plan, and it's inconsistent with the development pattern in the area, as Development Services staff has determined, among all the other objections. This board, finally closed the loophole that was allowing them to continue operating contrary to code, this buy here, pay here, used car lot with chain link fencing and a huge parking lot in the middle of Ruskin's town center for years, by delaying tactics, by saying, all right, well, we know we're violating code and everything, and we know we're not complying with the Ruskin community plan, but we're still in the process of coming to this zoning hearing that they started in 2018. We are finally, because we closed the loophole, letting them keep going and delaying, we're finally here in 2022 and able to, make a decision on this. They should have been shut down years ago. They show an artistic rendering of something that looks somewhat nicer than the used car lot eyesore that is at this downtown corner of Ruskin, and promise now that they would put some awnings over things and they would neaten it up and they would take away the chain link fence and all of that and show this picture. But they haven't done that. They've been operating since before 2014, and they haven't done that since. I mean, but now they're going to make it, take away the chain link fence. It is still going to be a buy here, pay here used car lot. And I find it particularly galling that the applicant is showing photos of the pawn shop, another eyesore in Ruskin's town center, as justification that they should keep their eyesore going, because what's Ruskin? It's just pawn shops and buy here, pay here used car lots. I mean, rather than saying that they will come do something to comply with the Ruskin Community Plan, they're trying to say, nobody else did. Well, at least there's this pawn shop that's not doing it, and so we shouldn't have to either. And as a last-ditch Hail Mary attempt here, they asked for another 5-year delay. They've been operating this for years and years, and now they want just another 5-year delay. It's time to make a decision. And I think you can tell where I'm going with that. But I do want to say, in the backup, we can see that it's incompatible. It's contrary to the Ruskin Community Plan, and it's incompatible with the Land Development Code, designation of the streets and the key standards. And the applicant acknowledges they cannot meet some of the key standards found in the Land Development Code, section 3.17.03, in our general development standards for the area. And specifically, they request cannot meet the design standards pertaining to off-street parking lots. It's located on main streets, not on the fringe, and the minimum building frontages and building designs and all of that. They acknowledge that. So therefore, they're seeking relief from the standards for Ruskin's Town Center. Development Services staff finds it inconsistent with the development pattern in the area, notwithstanding we have a pawn shop, okay? But with the rest of the development in the area, they're saying it's inconsistent. It's not compatible. It's not what the citizens of Ruskin worked so hard to determine for their community plan. Yeah, we have a Family Dollar. We made them go through a lot of design standards to comply with our town center community plan. This piece is just not doing it. It's got all recommendations of denial from the Zoning Hearing Master, Planning Commission, and Development Services, and I will make a motion to deny it based on those recommendations. And you've heard from the community, the Ruskin Community Development Foundation, which has been intimately involved in our community planning process as well as the updating process all along, is also coming here on record as wanting to move on from this to be able to continue implementing the Ruskin Community Plan and have the downtown center that we've envisioned and that we've been working with other developers all along to do.
Second.
Thank you.
We have a motion by Commissioner Smith, a second by Commissioner Kemp. Commissioner Kemp, you're recognized.
And I don't think a whole lot more needs to be said about this. But I'll just say, too, as many of you have heard, when I was an aide to Commissioner Castor, I really became very familiar with the community plans in District 1 and spent many an hour in Ruskin with Commissioner Smith in many ways spearheading the efforts down there, but 50 people would come to the meetings, 50 engaged citizens, really engaged, and as well with Town and Country and with Apollo Beach had gotten a feel and a flavor. And I share with you hopes for Ruskin having the town center that Ruskin deserves and that our community deserves in the future. One of the big barriers I think has been to the change there has, first of all, the kind of interest hadn't and the market hadn't shifted to Ruskin yet. But another big barrier was an infrastructure barrier of the low pressure sewer system, which really made it so, development, some of the businesses that may have considered going there couldn't go there. So I see great opportunities. I share your pain. I think along with Commissioner Overman, living in Seminole Heights off Florida, Nebraska, and Hillsborough Avenues, and hope that those areas too will, and are actually already, seeing a lot of changes, a lot better use of those opportunities. And there's certainly many places people will go out to wherever they're selling cars at used. People go out to those places, and they were originally in Florida Avenue, built out in the country, and now they're part of a dense metro area. So I assume that this business person will have the same opportunity, and they'll have people visiting there because, as we know, used cars now are a very desired commodity that people have difficulty getting. So I'm not really worried about that. But I also just think it's the defying since 2014 has been exhausting for the community. So I'll just say that, and I'm looking forward to a really better, Ruskin as a better place.
We have a motion by Commissioner Smith, a second by Commissioner Kemp. Any further discussion? With that, please take a roll call vote.
Overman?
Yes.
Cullen?
Yes.
Hagan?
Yes.
Kemp?
Yes.
Myers?
Yes.
Smith?
Yes.
White?
Yes.
Thank you. Motion carried 7-0.
Excellent. Thank you very much. Next item, please.
Brian Grady, Hillsborough County Development Services. The next item on the agenda is item F2, is rezoning application PD 20-1253. The parcel is located 508 north of the intersection of US 41 and Crystal Grove Boulevard on the east side of US 41. And I'm placing the arrow on the MO showing the location of the parcel. The request is for a rezone from ASC 1 to a planned development for a 5,000 square foot convenience store with gasoline sales. The applicant is requesting PD variation to landscaping and the buffering width along the portions of the eastern boundary. And I'll point that out where that area is. So they're reducing that to 10 feet. Also, there's a request for relief from the minimum pitch roof standard to the Lutz development design requirements. There is a rendering in the backup showing the proposed design, which staff does find supportable. Commissioners, this was remanded by the board. At the previous meeting, when this is before the board, the applicant was proposing a car wash, which raised concerns with the board concerning concerns regarding potential water quality impacts. There's also issues raised regarding lighting. It's upon remand, the applicant has removed the car wash request. They submitted a lighting plan showing that off-site lighting would be more restricted than the requirements of the Land Development Code, and there's a specific condition within the zoning conditions of approval outlining those standards for off-site lighting requirements for the project. Two other changes to highlight from the before this was when the highlight differences from when this was before the last time. On the site plan, during the remand, it was determined and discovered that the existing wetland that was in the southeast corner of the parcel was larger and required further delineation, so now that area is more accurately depicted on the plan in the southwest corner. I would note EPC comments are effectively not objecting to the site plan as shown with the proposed encroachments into that wetland. The other clarification in the record is regarding the relief from the pitched roof requirements of the Lutz Community Plan. Again, there is a rendering in the backup which provides the proposed, where they're providing a parapet on the roof to mimic a pitched roof. Staff was supportive of this change previously, and also this time nothing has changed with respect to that, but the prior report did mischaracterize that the relief was only from the rear of the building when all four sides of the board and the building need relief from that standard. Again, that was what was requested. It just was not correctly reflected in the staff report, but again, staff is supportive of that relief from the Lutz development standards. Again, staff, as with the prior application, did find this consistent and compatible with surrounding development pattern. It was found consistent by the Planning Commission and recommended for approval by the board, by the zoning hearing master. Staffs were available for any questions. Thank you.
Thank you. And at this time, we'll have, let me see, the applicant. Sorry. Applicant has 10 minutes.
Good morning, Commissioners. Cami Corbett with Hill, Ward, and Henderson. For the record, I do have a presentation for you this morning. Bear with us. As staff indicated, okay, go ahead. It's okay. I was going to just get started without you. It's okay. And go to the next slide. As staff indicated, this is a remanded hearing. Just to remind you, the development proposal is a next generation 7-Eleven located in one of the nodes specifically designated for neighborhood commercial within the Lutz Community Plan. Planning a brand new modern building specifically designed to fit in with the character of the Lutz Community Design Standards. This fulfills a need in the market, which is underserved by old, unattractive, poorly lit, and outdated quick marks. And then the developer, RKM Development, and 7-Eleven are committed to being good neighbors and are known for contributing to the communities where their projects are located. Next slide. The remand issues, as Mr. Grady indicated, there was a significant concern about the car wash aspect of this development. And you had requested that EPC provide further comment on that. At the hearing, we were actually asked if we could remove that car wash, and at that time, we were not at liberty to do that, but upon further review and discussion with our end user, we did agree that we would go ahead and just remove that car wash to eliminate that concern. Lighting impacts were also raised, and we indicated at the time that we would be compliant with your code, but we've actually provided a photometric plan in the record that shows that we'll be even more restrictive with our lighting than the code requires, and that's been added as a condition. Commissioner Smith did say that she welcomed additional testimony from the community and then further evaluation of the impacts to wetlands. Next slide. And so again, the rezoning request has now removed the car wash, and we've added additional acreage, 0.3 acreage, as Mr. Grady indicated, to sort of help us avoid those wetland impacts. It was always known that there was an upland cut ditch there. It just was when the wetlands were actually delineated, it was a little bit larger than what EPC had anticipated, and we have worked through that issue with them. And again, reminding you, we're at an 84% reduction in the allowable intensity for this site. Next slide. This is the photometric plan. Again, on the north side, we're 60% less than the maximum allowed, and on the south side, 30% less than the maximum allowed. Next slide. This is a rendering, and this rendering actually still has the car wash, but you could get the idea. This is what it would look like at nighttime. Next slide. And then again, with blue being the least illuminated and yellow and green and red being the most illuminated, this is what you would see from the subject site with the compliance with the photometric plan. Next slide. We did have additional party of record input. We had some folks who objected to the location of the hearing, some people who raised general environmental concerns. At one point, EPC had objected just because their wetlands had grown, and we've worked through that objection, and EPC no longer objects to this request. We had similar objections that were raised at the prior hearing regarding a prior zoning before the public potable water supply was removed, concerns about the private wells in the area, history of intersection at the development at the intersection at which we again presented evidence at the other hearing that Sunset Lane is being improved. And there was opposition to the wetland impact, but really none of the objections that were raised either after the remand or during the last zoning hearing master were really any new objections that hadn't been raised before. Next slide. Again, there's an on-site man-made wetland. The delineation showed a larger impact, and then the applicant acquired additional property to minimize that impact, and EPC does not require additional information. Next slide. We have no objections from any reviewing agencies, including EPC, Natural Resources, Environmental Resources, and Utilities. We have Development Services findings of consistency and compatibility, not only with the comprehensive plan, but the Lutz Community Plan, as does the Planning Commission find it consistent and compatible and consistent with the Lutz Community Plan. And these findings and conclusion of county staff constitute substantial competent evidence that the application is supportable. With that, I'd like to conclude my remarks and reserve any time for rebuttal. And I'm showing on my clock that I've utilized approximately 5 minutes.
Thank you very much. With that, we'll open it up for oral arguments by the proponents or opponents, parties of record. I have 3 individuals signed up. One is an applicant member, but the first 2 are providing testimony for opposition. I don't see anyone signed up for proponents. With that, I'll recognize Susan Guess, who is in person, I believe.
Please come. She's coming to the podium.
Okay, thank you.
Ladies and gentlemen of the BOCC, I do thank you for your service. According to the representative corporation, they believe that we need the 7-Eleven gas convenience store like our Dunkin' Donuts. I do strongly object. We have a gas convenience store called Blessings. Taking the car wash off the plans took 7 hearing changes and 2 submittals by the hearing master to submit this compromise card in an attempt to gain your acceptance. During this time, the habitat around us has been a refuge for different animals and birds. The hearing master and the BOCC approved this eyesore storage building on Highway 41 in Crystal Grove. This was a no objection by our speaker, who was obliged by his profession not to appear. We already went over the fact that I did work for a engineering firm, and Ms. Corbett did make a point to discuss my background. The storage company did destroy several acres and has displaced the wildlife that called the property protection and home. Now we're again burdened with another company that will continue this pattern. Statements made that there is a need for more businesses along this roadway, and we do not understand the aspects of growth like the engineers and the attorneys. Fact is, the storage company was forced on our neighborhood. Publix, the bank, and Dunkin' Donuts are almost 4 miles south, and the Walgreens was an old bank building. There's nothing wrong with slowing down growth when it affects will be unconsiderably harmful to our animals as well as humans, and felt for many years to come. I did submit some material by CETO Lab, and I'll just state one part of it. This conversion of Earth's land surface to urban uses is one of the most irreversible human impacts on the global biosphere. It hastens the loss of highly protected farmland, affects the engineering demand, alters the climate, and modifies hydrologic and biochemical cycles, fragment habitats, and reduces biodiversity. We see the effects on multiple levels. Future urbanization will, for example, pose direct threats to high-value ecosystems. The highest rates of land conversion over the next few decades will likely take place on biodiversity hotspots that were relatively undisturbed by urban development. And it states this in the CETO 2000. Findings reveal urban expansion will affect global climate. Direct loss in vegetation biomass from the areas with high probability of urban expansion is predicted to contribute about 5% of total emissions from tropical deforestation and land use change. I also refer to the small convenience store, Blessings. Blessings has been in our neighborhood for almost 30 years. They provide a good service to our community. They care about our community, and they are hardworking Americans. This prospective 7-Eleven store will definitely put them out of business. Our government seems to want to support these small businesses, the mom and pop businesses. Well, that's what our rural community supports. And we do ask that the BOCC please turn this zoning down so that we can continue to live in our community as a small neighborhood and a deeply close neighborhood. Thank you.
Thank you very much. There's 5 minutes remaining. I have another individual signed up as an opposition. Is Jay Muffley available?
Sam Calco, next. Would you please swear me in?
Sir, there's another person wishing to speak. He's at the dais. He says he's not been sworn in.
Please proceed.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And he has spoken at the previous hearings?
Yes.
He has, okay.
Yes.
My name is Sam Calco, living at 18422 Swan Lake Drive, Lutz, Florida, 33549, and I'm a board member of the Lutz Citizens Coalition. And I would just like to say that today's hearing should be stopped and continued. There has not been a proper sign notifying the people of this hearing on that property. This case started in December of 2020, and there always has been notices of the hearings on the property, every one of them, except this one. There has been no sign notifying the public of this hearing. I make a motion that we continue this hearing.
Are you finished, sir?
For now.
Okay, thank you. There are 4 minutes and 43 seconds remaining for opposition testimony. Are there any other individuals that wish to testify? Seeing none, we will.
There's another person coming. There's another person approaching.
Oh, there's another person arriving? Okay.
I've not been sworn.
Can you please?
Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Please proceed.
Good morning,
State your
Max.
name, please.
What?
Please state your name.
That's what I was doing. Max Forkey, 236 Southeast 45th Street, Cape Coral, Florida, member in good standing of the American Institute of Certified Planners since 1993. Commissioners, Lutz is one of 3 rural designated communities in your comprehensive plan. This is a contentious and complex case. Your justifications for denying it outright are specifically 6 inconsistencies with your comprehensive plan, beginning with the rural definition at page 1. The definition of the residential 2 future land use element definition. This is RES2, and on 360 degrees on all sides, all property that touches it is residential 2, notwithstanding what was said in the hearing officer's report. It is inconsistent with the purpose statement on pages 1 and 2, which draws a clear distinction between long-range urban and rural forms. It is incompatible with future land use element policy 1.4 and also with state statutes section 163.3164 paren 9, which defines compatibility. It is inconsistent with the rural densities articulated in policy 4.1, which allow density no higher than 1.1 unit per 5 acres. I know that there is a distinction between density and intensity, but that is a guideline. It is inconsistent with objective 16 and policies 16.1, 0.2, and 0.3 of your future land use element. It exceeds commercial criteria and ignores the flume designation. It is inconsistent with your, it would create an inequality between my neighbors, my clients, and the applicant because it would allow a use not now allowed in the existing ASC 1 zoning category, which allows 13 permitted uses, 52 conditional uses, 13 special uses, which are good enough for my clients, but apparently not good enough for the applicant. The existing zoning is appropriate and adequate. This would create a spot zoning situation, and as I have said, an equality of uses. It fails the twofold Snyder test. It is inconsistent with the plan and the procedural requirements. You will hear more, I hope, on the inadequacy of the wetlands declaration. I wish I had more time. I wish I had an opportunity to present you with a complete report. But that's the time I have. Thank you, Commissioners.
Thank you, sir. Are there any other, there's about a minute left for any other testimony.
Gentlemen, come to the front.
Okay.
Morning, Commissioners.
You have a minute, 3 seconds, sir, remaining for opponent testimony, assuming you're speaking on opposition.
Good morning, Commissioners. Jay Muffley, 102 Fifth Avenue Southeast, Lutz, Florida, representing the Lutz Civic Association. The Lutz Civic Association opposes this rezoning with wetlands on this property. It would be a threat to our environment, the wetlands, the wells, public and private, and Lake Stemper. Looking at the wetlands, Lutz K8, which is Lutz School, coming south from the pond onto this property by the red dot, flowing on south next to Sunset Manor, under Sunset Lane, and proceeding south. Sunset Manor has a public well swift mud permit 20008788.004. Looking at the wetlands from the 7-Eleven, moving south.
I'm sorry, sir. The time set aside for opposition testimony has expired.
Pardon? Time is up. How can we condense 15 minutes into 10 minutes? Good question. Thank you.
I'm sorry, what was the question? Currently, we have 10 minutes set aside for opposition testimony, and that time has expired at this point.
But
Ms. Lundgren, would you like to offer us some guidance?
The code does provide for 10 minutes for the opponent's parties of record. So that time has expired, and I'd advise the board to advise the speaker accordingly.
Okay. Yes, your time has expired, sir. We shall move on to rebuttal by the applicant, and 5 minutes has been set aside for that time period.
Cami Corbett for the record. I did ask to reserve some of my direct time for rebuttal. Hopefully we won't take the entire time, but I do want, there's a lot to cover here. Just wanted to put up first a map of the surrounding area again to reorient you, but with the actual, on an aerial of what the actual uses are in the immediate surrounding area. You could see the self-storage, you can see the Walgreens, you see a McDonald's, and then you actually see a mall to the south. And you will, as you know from the backup and from the Planning Commission staff and Development Services analysis, this is in a commercial, it's in the commercial node specifically set aside in the comprehensive plan for this kind of activity to address compatibility concerns within both the Lutz community plan and within the R2 area. So while I appreciate Mr. Forgey's statements, I don't think he's accurate on how to interpret the Hillsborough County comprehensive plan. I think he just has that wrong. The comprehensive plan very specifically and directly directs this type of development to this location. And as I testified earlier, we are an 84% reduction to the allowable intensity that is allowed in this commercial node. As far as the proper signage issue, I believe that not only was this properly noticed, Mr. Calco is here, so he must have received notice of the hearing, and so I think that would serve to waive any concerns he might have with respect to that. I'd like to ask Dale Merriman to come up. He is our wetlands expert to testify to some of the issues that were not really fleshed out, but touched upon by some of the citizens.
Good morning, Commissioners. Dale Merriman, 10408 Bloomingdale Avenue, Riverview 33578, and I have been sworn. One thing that I would like to make note of is that the property that we're talking about is not considered significant wildlife habitat, never has been. The area, and I'll point it, has historically been orange groves, and as progress has happened in that area, different areas of the orange grove have been sold out, and in this case as well. The wetlands that they were discussing, we have delineated. It's been certified by both EPC and by SwiftMud, so there is no discrepancy on that. The area, historically being an orange grove, had a ditch at the bottom southeast corner, which was just for the normal outflow of water from their irrigation. In this particular case, once they removed the trees, as you can imagine, and I'm sure plenty of people have seen this, it leaves a depression in the ground. Over time, that depression has expanded a little bit, and has become wet only because the ditch is now running into some of those areas where the trees were. Long story short, it is an artificially created wetland. It has half upland, half wetland plant material in it, but everything has been reviewed by the agencies and approved, and we rest on our record for the environmental. Thank you.
Thank you. There is a minute 35 remaining for the...
No, I'd like to ask Mike Alfieri, who is our hydrogeologist, to come back up and remind you about the hydrogeology in the area.
Thank you.
Good morning. Mike Alfieri, 14033 Vanguard Way, Odessa, Florida.
I work for Water Science Associates, headquartered in Fort Myers, Florida. Again, in terms of the hydrology out here, there's two major aquifers out here. There's the superficial aquifer and what's referred to as the upper Floridan aquifer. The upper Floridan aquifer is what most folks in the area use for potable supply. In the past, there were two wells, the Crystal Manor wells. One was abandoned by Tampa Bay Water, while the other one was transitioned to a monitor well in the area. Because of this, the Zone 2 designation was removed and the Zone 1 designation remains. Zone 1 protects the domestic supply. The groundwater flow in the superficial aquifer is to the southeast, while the flow in the upper Floridan is to the southwest. The wetlands abut on the west side. Any septic that's put on the property is going to create a very small mound. The groundwater gradient, or the ability for water to flow and create a flow rate, think of like a ball on a hill. The higher the slope, the faster the ball will roll. That's your gradient. Out in this area, there's a very, very shallow gradient. Water does not move fast at all. With the technology that's used out there for these types of uses for gas stations with double wall liners and monitoring with a slow, flat gradient like
Thank
we
you,
have.
sir. Thank you, sir. Your time has expired.
No problem. Thank you.
Thank you very much. The Planning Commission.
Thank you, Melissa Leinhardt, Planning Commission staff. The subject property is located in the residential 2 future land use category. The site is located in the rural area and also within the limits of the Lutz Community Plan. This request was heard at the October 12th, 2021 Board of County Commissioners Land Use Meeting, where it was remanded to the zoning hearing master due to concerns regarding site lighting, potential car wash runoff, and meeting the vision of the Lutz Community Plan with regard to commercial nodal placement. To address those issues, the applicant has removed the potential for a car wash from the plan development application and has submitted a photometric lighting plan. With this remand, it should be noted that it was discovered that the site does meet commercial locational criteria as outlined in future land use element objective 22, details of which I'll provide in just a minute. The Lutz Community Plan establishes certain commercial nodes and encourages commercial development within these areas. The subject property is located along US Highway 41 near the Sunset Lane and US Highway 41 intersection, approximately 460 feet away. This area along US Highway 41 from Crystal Lake to Sunset Lane is identified as a location in the Lutz Community Plan where commercial development is desired. Consequently, the request for a 5,000 square foot convenience store with 14 gas pumps is consistent with and helps facilitate the vision of the Lutz Community Plan. In addition, the site meets policy direction in the comprehensive plan that seeks to direct non-residential development to major intersections, otherwise known as commercial locational criteria. During this remand, it was discovered that this site does meet the more traditional application of commercial locational criteria. 75% of the site is located within 900 feet of a 2-lane roadway, which is Sunset Lane, and a 4-lane roadway, which is US Highway 41. Therefore, the site not only meets the vision of the community plan by being near a node identified in the plan, but it also meets the traditional application of commercial locational criteria by being within 900 feet of a qualifying intersection, which is consistent with policy direction. Future land use element policies 16.1, 16.2, and 16.3 require new development to be compatible with surrounding uses. A light commercial use is located south of the subject property, and single-family uses are located to the north of the subject site. The proposed gas station and convenience store are placed further south away from the single-family residential lots to the north. While access to the site is provided on the northern portion of the site, a 30-foot Type-C landscape buffer and a 6-foot masonry wall are provided to the north. The site planning technique provides a gradual transition from the proposed development to the existing single-family residential lots, consistent with policy direction regarding compatibility. Future land use element policy 16.3 emphasizes the importance of integrated development with adjacent land uses through transportation and pedestrian connections. Further policy direction regarding the importance of vehicular and pedestrian connectivity is provided in the community design component. The applicant is proposing cross-access between the site and the balance of the folio that is not part of the proposed plan development. A stub out for future cross-access has also been provided to the north of the subject property, and there will be a connection to the existing commercial use to the south. The connectivity shown on the site plan is consistent with policy direction in the comprehensive plan. Policy 16.5 of the future land use element requires development of higher intensity non-residential land uses that are adjacent to established neighborhoods to be restricted to collectors and arterials and to locations that are external to established and developing neighborhoods. The proposed rezoning is located on US Highway 41, which is an arterial roadway. The request satisfies the intent of this policy direction. And lastly, the site is subject to the Lutz Rural Area Design Standards in the Land Development Code. The applicant is requesting relief from the roof pitch requirement on all four sides of the proposed convenience store building because, as the applicant's narrative asserts, a flat space on the roof is needed to provide, in order to provide an area for the building's equipment as opposed to placing the equipment on the ground level. The applicant is proposing the alternative of raised parapets that provide for a similar appearance to a pitched roof on the southwest and north sides, which are the sides that are visible from US Highway 41. Elevations have been provided in the backup materials that demonstrate how the applicant will meet the remaining Lutz Rural Area Design Standards. These design standards help to implement the vision of the Lutz Community Plan because the raised parapets will have a similar look and scale to the required roof lines based on the submitted elevations. Planning Commission staff is supportive of this variation from the requirements. Ultimately, the proposed convenience store and gas station will be in character and scale with the rural look of the community, which is consistent with the community plan vision. And based upon those considerations, Planning Commission staff finds the proposed development consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County, subject to the conditions proposed by Development Services staff. Thank you.
Thank you very much. With that, we'll hear from the zoning hearing master's recommendation. Summary?
The zoning hearing master considered the request to rezone approximately 2.91 acres from ASC 1 to planned development in order to develop a 5,000 square foot convenience store with 14 fueling stations. The zoning hearing master summarized that the rezoning request includes planned development variations that would reduce the required 20-foot wide buffer to 10 feet on the eastern side. Additionally, the applicant requests to provide a flat roof instead of the pitched roof required by the Lutz rural standards. The zoning hearing master found that this PD variation meets LDC section 5.03.06 CB, as the applicant's representative testified at the prior hearing that the reduction in buffer width on the east side is a result of the desire to move the building away from the residential. Additionally, the applicant's representative testified that the required amount of screening will not be reduced, thereby meeting the intent of the LDC by mitigating this reduction in buffer width. The zoning hearing master found that the request for a flat roof instead of the required pitched roof is justified by the fact that the flat roof will have slope parapets along the northern, southern, and western sides of the structure. The overall design of the convenience store was found by the ZHM to be rural in character. As you've heard from the Planning Commission staff, the Planning Commission staff found the site to meet commercial locational criteria and to be consistent with the Lutz Community Plan and the comprehensive plan overall. The property was subject to a recently approved comprehensive plan text amendment, which removed this Zone 1 wellhead protection area designation from the site, as the Crystal Lake Manor wells have been decommissioned by the board. The zoning hearing master summarized testimony in opposition that was provided at the hearing. The testimony included concerns regarding compatibility as well as potential negative impacts of the installation of underground gas storage tanks. Both planning staffs of the Development Service Department and the Planning Commission staff found the proposed land use compatible with the surrounding area and consistent with the code and comprehensive plan. The applicant's representative testified that the project will be consistent with the Lutz Community Plan standards with the exception of the flat roof instead of the required pitched roof. Approval of the plan development zoning with the conditions proposed by the Development Services Department serves to provide a compatible land use in an area given the surrounding non-residential development and location of the property fronting on US Highway 41. The zoning hearing master stated that the proposed connection to public water and the use of a septic system is in accordance with the utility requirements for the rural service area. The zoning hearing master concluded that this request is compatible with the character of the area given the existing non-residential uses to the south and west and is consistent with the intent of the LDC and the comprehensive plan. The zoning hearing master therefore recommended approval of the plan development rezoning request.
Thank you. With that, I'll open it up for board discussion, and I don't see anyone asking to speak. I did want to make an observation here. You know, I've had a couple of conversations with development staff about this section of our county. This is sort of in between two urban areas. It's literally, we've got the section of the urban service area to the west that goes up to Pasco County line, with Del Mabry and 41 going through the middle of the rural area. Right next to the east is the city of Tampa. So there's this little rural area, which is lovely, and that's why the Lutz Community Plan is so important as it develops. But this is US 41. This is a US highway that runs through the middle of this area where commercial development has been encouraged as part of the commercial plan. So with that, I'd like to see if we have a motion and a vote on this particular item.
Move for approval.
Second.
We have a motion by Commissioner Myers, a second by Commissioner Cohen. Any further discussion? Seeing none, please take a vote.
Overman,
Yes.
Cohen,
Yes.
Hagan,
Yes.
Kemp,
Yes.
Myers,
Yes.
Smith,
Yes.
White.
Yes.
Motion carried 7-0.
Thank you very much. With that, we'll move to F3.
Commissioners, the next agenda item is agenda item F3. It's major mod application 21-0169. The applicant's Todd Pressman. The request is for a major modification to a plan development to do a 16-unit multifamily units and one mobile home. Commissioners, this was before you at a previous board meeting, and as part of board discussion after presentations, the staff presentations and the applicant presentations, as part of, again, board discussion, the board continued this item to allow the opportunity for the applicant to add a condition regarding a commitment to a conservation easement to the proposal. You will recall that the issue with this case was the fact that it was non-compliant with mixed-use policies in the comprehensive plan, and the focus of the reasons for non-compliance with those requirements was the large wetland that comprised the majority of the parcel that bifurcated the areas where the proposed uses were. And as part of discussions about potential approval of this, the board did continue this to ask the applicant to consider adding a conservation easement to the revised proposed conditions. That has been done. The revised conditions begin on page, I believe, 47 of the backup, and the proposed additional condition is condition 14. Therefore, again, this was at board discussion when this was continued. And again, the applicant has provided that condition, and we're available for any questions. Thank you.
Thank you very much. With that, we can hear from the applicant. Is the applicant present?
Good morning, Madam Chair. Todd Pressman, 202nd Avenue South, number 451, St. Petersburg, Florida. I have a PowerPoint for you.
And have you been sworn? Do they need to be sworn in?
I have been, yes.
Okay, great. Thank you.
This is 21-0169 major modification. Next slide, please. Major modification to change what is currently 62 multifamily dwelling units to only 16 multifamily dwelling units and one mobile home on 21.8 acres. Next slide. Zoning tells you it does not create further incompatibilities. Planning Commission is compatible with the development area. Planning Commission is consistent with the vision of the community plan. Project is in the USA. It's an infill project. Next slide, please. Located near the Mango Sefner area. Next slide, please. A little closer. Next slide, please. And this is as the property appraiser has it in the USA. Next slide, please. There are extensive wetlands throughout the area. Next slide, please. This is Fish and Wildlife, the wetland area as they map it. Next slide, please. So to jog your memories, commissioners, which I'll get into, but I want to remind you up front that the Planning Commission policies would literally require us to provide interconnection between the two different elements of the property, 16 apartments and mobile home properties, which of course we're not going to do, but that is part of the incongruity of the policies on this site. Now, this is also a remand, and as Mr. Rady has indicated, to meet your directive or your desires, EPC has communicated in writing that they will accept this as a conservation easement. Next slide, please. And this is a communication from Mike Thompson, Senior Environmental Analyst, that they will accept it as a conservation easement, which we're happy to do. Next slide, please. That meets one of the Planning Commission, one of the comp plan policies to regulate and conserve wetlands through the application of regulations and such. Next slide, please. This is the prior site plan, which a prior rendition actually included a warehouse. We pulled obviously this way back, which was, we are now proposing only 16 apartment units and one mobile home. Next slide, please. Showing you that everything is very small into the corner. Next slide, please. These are some of the surrounding residential units or homes in the immediate area abutting the site. Next slide, please. And next slide, please. So the proposed site plan and comp plan, next slide, please. Showing you all the wetlands, and up in the corner would be the 16 units. Next slide, please. Again, showing you where one mobile home would be and the single family. You can see it's just a very tiny, small part of the whole property. Next slide, please. And next slide, please. This is a blow up of that little corner. It would be 2-story unit apartments. The mobile home unit is located way on the other side. Next slide, please. So conditions so far is a 30-foot height maximum. We would meet the RMC 20 code. The mature oak trees on the north edge in the upland area would remain. Next slide, please. So to show you the schematics, 80% is wetlands, only 6.1% is buildable per the engineering plan for the site. Next slide, please. And this would be obviously a fantastic and tremendous savings of preservation of pristine wetlands, which again, at the direction of the commissioners, would be a conservation easement. It is a tremendous reduction of what is currently on the records under the PD of 61 apartment units. Next slide, please. The surrounding future land use category is UM20, which allows 20 dwelling units per acre, and also UMU20 includes this site. Next slide, please. And the zoning in the area includes a wide range of residential, so we're certainly compatible with that. Next slide, please. UMU20 is really designed as residential, large regional business park, research park, multi-purpose future land use category. Again, allows 20 units per acre. Next slide, please. Staff comments. Next slide, please. PGM staff, it's comparable to the residential uses. Wouldn't create further incompatibilities. Planning Commission compatible with surrounding development pattern per number of policies and objectives. Next slide, please. Planning Commission is consistent with the Sefner Mango Community Plan and supports infill development USA. Next slide, please. Indicating we're requesting far less than what even could be considered under the land use category, which would be 110 residential units. We're doing roughly 10% and being environmentally sensitive. Next slide, please. The question is then, what's the problem? What's the issue? Next slide, please. There are two policies that the Planning Commission staff is standing strong with and that the zoning hearing master applied, which is 19.1, which only refers to very large projects, 10 acres or greater. 10% of the building square footage shall be for two uses, which we do not meet. Although, if I may, in my opinion, we're providing wetlands as a conservation area, one mobile home, and apartments my opinion is those are different uses, but I don't get a vote on that decision. So next slide, please. The intent of policy 19 is residential, regional, commercial offices, business park, research park, light industrial, which of course what's presented to you is not anywhere near. Next slide, please. The other policy requires an internal connection between the uses. So although we're providing different uses, we would have to provide integration and connectivity between the uses. Next slide, please. So those are the two policies that the Planning Commission, not speaking for them, but as I understand the Planning Commission is providing as, with everything else positive you heard, while they're not supporting the request, these two concepts. As well, when you read the zoning hearing master report, not negative or a complaint, she just reads those same policies as her negative position. Next slide, please. And again, that would require us to literally build a road between those uses throughout the pristine wetlands and provide a second use. And clearly, we could have provided a small footprint office. We could have provided some other smaller use, but it doesn't work or fit here to what's proposed for the residential, which you've been told by the Planning Commission and zoning, it is compatible. Next slide, please. Next slide, please. And this is a follow-up that we're far below the abilities and entitlements on the site. Next slide, please. So clearly, the trips and impacts are tremendously reduced from what's on the record and what the future land use category could allow, approximately 10%. 126 average daily trips are reduced tremendously. The AM peak is reduced by 25 in the AM and reduced by 30 in the PM peak. Next slide, please. So summary, we're being extremely environmentally sensitive, consistent with the Sefner Mango Community Plan. The intent of just two policies are very large square pegs trying to get into a small round hole. Proposed use is compatible, less intensive, infill in the USA. And to this date, we have received absolutely zero public opposition. We're happy to answer any questions you might have. Thank you.
Thank you very much. With that, we will hear from any opponents or proponents. I don't see anyone signed up for this item at this time. And with that, we'll move on to, I would assume we don't have a rebuttal because we don't have opponents or proponents. So with that, we'll move to the Planning Commission staff.
Thank you. For the record, Melissa Leinhardt, Planning Commission staff. The subject property is located within the urban mixed-use 20 future land use category. The site is located in the urban service area and also within the limits of the Sefner Mango Community Plan. The purpose of this application's remand was to give the applicant an opportunity to address staff's non-support of the application. Since the first remand, the applicant has proposed a less intense use of 16 multifamily residential units and a mobile home. Future land use element objective 19 outlines the intent of all mixed use categories in the comprehensive plan. Specifically, future land use element policy 19.1 states that requirements for two land uses will apply to properties that are 10 acres or greater in the RMU 35, UMU 20, and CMU 12 future land use categories, and to properties 20 acres or greater in the SMU 6 and NMU 4 future land use categories. Furthermore, according to policy 19.1, at least 10% of the total square footage of the building if vertically integrated, or 10% of the project area if horizontally integrated on site, must be dedicated to the second required use. The site also must be designed with internal connections between those uses. The request does not meet the mixed-use provisions of the comprehensive plan as outlined in Objective 19 and policies 19.1 and 19.2 of the future land use element. Though the applicant is requesting two distinct uses per policy direction, the uses need to provide integration and connectivity between the uses, and additionally, the second use being provided would need to be at least 10% of the site acreage. Though the requested use can be considered within the UMU 20 future land use category and the uses meeting the intent of the Sefner Mango Community Plan, without the request meeting the merits of the mixed-use policies, Planning Commission staff finds the proposed request inconsistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County. Thank you.
Thank you very much. We'll move on to the zoning hearing master's recommended summary.
The zoning hearing master considered the proposed major modification request to Plan Development 2071, which is currently approved for 62 multifamily dwelling units and 5 mobile home dwelling units. The request proposes to permit 16 multifamily dwelling units and 1 mobile home. As you've heard, the Planning Commission found that the request does not meet the requirement for 2 land uses, or I'm sorry, that it does meet the requirement for 2 land uses, but it is inconsistent with the comprehensive plan, as the 2 land uses are not integrated and connected. Planning Commission staff also found that the second land use for the single mobile home, excuse me, does not equate to the minimum UMU 20 requirement that at least 10% of the total square footage of the building and the project must be designated for a second use. Development Services staff also does not support the modification, as it found that the modification does not meet the UMU 20 requirements for integration and connectivity, as well as the requirement that the second use be at least 10% of the square footage of the project square footage. The zoning hearing master found that no testimony or evidence was provided as to whether the project could comply with the requirement that the second land use building square footage comprise at least 10% of the total square footage of the project if the number of mobile homes were increased. The zoning hearing master concluded that the proposed major modification request is inconsistent with the comprehensive plan and recommended denial.
Thank you. And with that, we'll open it up for board discussion. Commissioner Kemp?
Yes, thank you. My first question for Mr. Pressman, I just wonder if that highway and cars are to scale. I think I dream about that at night. You know, I feel like I've been through this rezoning so many times, but I actually have learned a lot in it. It's been interesting. I understand some of the rules and why they apply and why they would apply to a spot of this kind of size of dry acreage in the right place, or why the comp plan rules. And I can see the wisdom of them, but obviously I think pretty obviously they don't apply here. I appreciate that we now have this great conservation easement over this property at this time. And I think this development in this case, in this way, makes a lot of sense. So with that, I'll move approval.
Second.
We have a motion to approve by Commissioner Kemp, a second by Commissioner Smith. Is there any further discussion? Seeing none, please take a roll call vote.
Overman?
Yes.
Cohen? Yes. Commissioner Cohen? Hagan?
Yes.
Kemp?
Yes.
Myers? Yes.
Commissioner Myers is indicating yes.
Smith?
Yes.
White?
Yes.
Motion carried 7-0.
Excellent. Thank you very much. I am off to F4. Thank you very much.
The next item is agenda item F4, Rezoning PD 22-0439. The applicant's Bel Air Development Incorporated. The request is rezoned from CPV G6 to a planned development. Israel Monsanto with county staff is online, and he'll provide a brief overview of the request. Thank you.
Good morning. Can you hear me?
Good morning. We can hear you. You are with Development Services, so please do.
Yes.
You have 5 minutes. Thank you.
Thank you. Israel Monsanto Development Services. The applicant seeks to rezone a parcel from Citrus Park Village G6 to a planned development to allow the development of an automated car wash facility. The proposed use will have access from existing shopping center located at the northeast corner of Gunn Highway and Sheldon Road in Citrus Park. The site is within the Citrus Park Village Community Plan area and is subject to regulations of the Land Development Code Part 310 Citrus Park Village Development Standards. The surroundings consist of commercial and retail uses. The area also consists of single and multi-family residential uses. The car wash facility will be 6,445 square feet in size with associated parking and vacuuming spaces for customers. Since the site is within the Citrus Park Village area, it is subject to the development standards established in the Code Part 310.00 for building placement, and designed for non-residential uses. This subdistrict designation for the property permits commercial neighborhood uses. Additionally, due to the restricted depth of the subdistrict, the code allows parking areas to be located to the side or rear buildings. The applicant worked on different site layouts and designs to ensure the project conforms as many to Citrus Park Village regulations as practical. The site is along a shallow parcel with significant frontage on Gun Highway and surrounded on its three sides by a public-anchored shopping center zone PD. According to the applicant, the characteristic of the site makes it difficult to meet all of the overlay requirements. Therefore, a PD is proposed. The applicant proposes a general site plan depicting the layout of the site in addition to a building design which would provide an overall project that conforms to the greatest degree practicable with the provision of the Citrus Park Village regulations. There is a number of Citrus Park Village standards that the proposed site will partially comply, for which the applicant has provided justifications to waive this. In summary, the project would conform with most of the building placements and architectural standards established by the Citrus Park Village regulation by providing facade designs of a Florida vernacular style with features and elements in accordance with the Citrus Park Village regulation and also in harmony with the shopping center approved design located to the north. The building will also have a look of a two-story structure, which is not required by the subdistrict, but is a feature that nearby Citrus Park Village subdistricts require in order to provide a pedestrian-friendly walkabout experience. The building will extend to meet a setback requirement. The two standards that will not be met entirely, which are block pattern and maximum impervious surface, staff finds the justification from the applicant reasonable. The existing development pattern surrounding the subject site prevents the establishment of a new block, and the proposed project seeks development of an existing single parcel that has been vacant since the adoption of the Citrus Park Village regulation and is also recognized by the code. Transportation staff also reviewed this waiver and finds that the request is acceptable. The proposed increase in impervious surface is also reasonable since the original limits of the property have been reduced due to road expansions in the area on Gun Highway. The original parcel was approximately 0.75 acres, but the site today is only 0.59 acres. Therefore, the main reason of the increased percentage of the impervious area is due to the reduced acreage that resulted by that road expansion. Still, the requested impervious surface is below 70% of the parcel area and is consistent with the development standards of nearby commercial sites. All other development standards will be in accordance with the Citrus Park Village regulations. And that concludes my summary.
Thank you very much. I appreciate that. We have 10 minutes set aside for the applicant's oral arguments. Is the applicant present? I see several people from the applicant's team signed up to speak on this item.
Yes, Madam Chair. My name is Nicole Neugebauer. I'm here today to give a brief presentation of the Bel Air Development Group application.
Go right ahead.
Am I able to share my screen for a PowerPoint presentation?
I don't object. Is that, can communications accommodate?
If you go down to your WebEx session, at the bottom of the screen, there's a share button.
Good morning, Commissioners. My name is Nicole Neugebauer. I'm a land use attorney at Stearns Weaver Miller in Tampa. My address is 401 East Jackson Street for the record. I'm here today for a property that is generally located in Citrus Park. The property is 0.592 acres and is located north of Gun Highway and east of Sheldon Road. Sickles High School is just to the west of this project, and there is a large Publix anchored shopping center to the north. The property is currently zoned CPV G6 and is within the CPV subcategory G future land use category. The property is also within the urban service area. The property is currently vacant. As I mentioned, to the north, there is a Publix, a Walgreens, and various other retail uses. To the south, across Gun Highway, is the Victory Charter School and We Care Pharmacy. To the east is a bank, and to the west is Sickles High School. Here's a copy of our revised site plan. As you can see, this is a very irregular and oddly shaped lot. The west side of the property is about 66 feet in depth, and the east side is about 88 feet. Over time, an FDOT taking occurred, which narrowed the property. The proposed use is a fully automated car wash, which is allowed within the CPV G6 zoning category. That zoning category allows CN uses, and an automatic car wash is a CN use. That's very important today because even though this type of use is allowed on this property, we are here today because of some of the design requirements for the CPV zoning category. As I mentioned, this is a request for an automatic car wash. It'll be about 6,445 square feet. While it seems very large, that is because the building will appear to be 2 stories because the equipment and mechanical room will be on the 2nd story. There's no access for any customers to that. It's just purely for equipment. There will also be self-service vacuums, and staff will only be present during operating hours to ensure that the equipment is working and to help out with any kind of issues with the property. Consistency with the Citrus Park Village plan. The CPV plan was drafted to achieve a well-balanced variety of residential, recreational, and commercial uses. The automatic car wash would be the only car wash within the CPV sub area. In addition, it will not alter the existing neighborhoods because this parcel would be in the front of an existing shopping center. We're proposing a 0.25 FAR, which is consistent with the CPV subcategory. Again, this area is replete with commercial uses with that Publix anchored shopping center, and this is an ideal use for that oddly configured lot. Consistency with the Citrus Park Village zoning requirements. With the CPV zoning, there are several design and architectural requirements. The requirements are required to be met to the greatest extent practicable. We meet nearly all of these criteria to the greatest extent practicable, and there are only 2 that we are unable to meet. Specifically, the build to line, because of this irregular shaped lot, we are able to meet this requirement on 67.5% of the property. There's also a canopy to try and maximize our consistency with this requirement. For the accessory uses, we do have vacuum stations that are located in the side yard. However, this is very similar to a parking use, and parking is permitted in the side yard. In addition, we're meeting all buffering and screening requirements. We have the minimum requirements for the facade, which would be a traditional Florida cracker architectural design. The design of the project is to look like a commercial use. In addition, with the storefront, again, we are trying to mimic a commercial facade, which will increase pedestrian access, connectivity, and activate the streetscape. We also have exterior cladding that we satisfy. The expression lines, again, we are going to be a 2-story building. Even though it will appear that the people can only access the 1st story, it will look like a 2-story building. We have awnings, structural canopies, roof requirements, cornices, parking will be provided. There's also a 2nd requirement for that build to line. Again, we will meet that 67.5% of the property. And the dumpster is located to the rear of the property and will be shielded from the right-of-way. Here you can see a picture of what the car wash would look like. The only difference is in the front elevation for this property. It shows parking spaces. That will not be on the final project because the front will be facing Gun Highway. The rear will be facing the existing public shopping center. People will enter and exit through the existing public shopping center access point, so we will not be adding any curb cuts onto Gun Highway. We have incorporated glass and shutters and this mural for an aesthetic commercial storefront. And we are committed to providing these elevations so the county is comfortable that we will be meeting the CPV design requirements as I presented to you today. As you can see here, these are the west and east elevations. We have used the canopies throughout the design so that the project will not look like a big box, but it will have some different architectural finishing to be consistent with the existing neighborhood. As I mentioned before, there are 2 requirements that cannot practically be met for this project due to the irregular shape. The first one is the block pattern. This property is too small to create its own individual block, and we are adding it to an existing shopping center. Second is the impervious surface ratio. We are proposing a 69% impervious surface ratio, but due to that taking, it reduced the property square footage, and that has we are unable to meet the impervious surface ratio because of this car wash use. Staff reviewed these justifications for all of the criteria and found that these requirements were met to the greatest extent practicable and our justifications were reasonable. Again, with the CPV zoning requirements, when staff evaluated these, they determined that the overall project conforms to the greatest degree practicable. Notably, the project's parcels surrounding the site were mostly developed prior to the CPV adoption. Right now, I believe this is the first project that has come in as a commercial PD with the CPV design requirements. This project is bringing the area closer to the CPV community vision and is harmony with this mixed-use district. Transportation and connectivity, there are 2 administrative variances due to the existing turn lanes that have been deemed approvable by the county engineer. In addition, you'll also might remember in March, we came to you with a PRS to modify that Publix anchored PD to the north to allow for ingress and egress through that shopping center, again, to minimize any additional curb cuts onto Gun Highway. Here you can see the red circles are the primary access point from the public roadways, and the green circle shows an emergency only access point. This will be gated and will just be emergency egress for any ambulance or emergency vehicles. Hillsborough County staff has recommended approval with conditions. Planning Commission staff found the project consistent. The zoning hearing master has also recommended approval, and we respectfully request that you approve this plan development. And I'm available if you have any questions. We also have our transportation and civil engineer available, and my client's also on the phone.
Thank you very much. Yes, 2 minutes remaining for the applicant. Are there other individuals that want to speak on behalf of the applicant? I see several people signed up.
Not at this time. Everyone is available for questions if the board has any.
Okay, thank you very much. With that, we'll move on to the oral arguments regarding a proponent or opponent. I do not have any parties of record actually signed up to speak as opponents or proponents at this time. So we will move on to either more from the applicant or Planning Commission staff.
Thank you. Melissa Leinhard, Planning Commission staff. The subject property is located within the Citrus Park Village future land use category. The site is located in the urban service area and also within the limits of the Citrus Park Village community plan. The subject site is located within sub-area G on the Citrus Park Village plan boundary and land use category sub-areas map. The intent of sub-area G is to recognize existing development within this sub-area. The sub-area will allow for commercial, office, and residential land uses or a mixture of these uses. This sub-area allows for a maximum non-residential intensity of up to 0.25 FAR, and the proposed rezoning is proposing an FAR of 0.10, which is consistent with the intensity expected in the sub-area. The Citrus Park Village Community Plan is implemented through the adoption of a specific district plan and regulations in the Hillsborough County Land Development Code. Detailed standards for land uses, densities, and intensities and design requirements are defined within the Citrus Park Village Zoning District Plan. The proposed rezoning will meet all but 2 design requirements, which are maximum impervious surface and block pattern. According to the applicant's narrative, due to the physical constraints of the site, it is too small to meet the impervious surface of 60%, where 69 is proposed, and create its own block face, and has requested a waiver, both of which are supported by Development Services staff. Objective 16 and its accompanying policies in the future land use element require that new development protects established neighborhoods and be compatible with the development pattern in the surrounding area. The proposed site plan shows the building located at the build-to line on the street frontage and the landscape buffers on all 4 sides of the property. Therefore, it is compatible with the existing development pattern and is consistent with future land use element Objective 16 and its policies relating to neighborhood protection. Goal 12 and Objective 12-1 of the community design component in the future land use element require new developments to recognize the existing community and be designed to relate to and be compatible with the predominant character of the area. The surrounding land uses are light commercial, including a pharmacy, grocery store, and bank directly to the north, east, and west. The proposal will be compatible with the existing character of the surrounding area and is consistent with this policy direction. The intent of the Citrus Park Village Community Plan is to ensure the development of a well-balanced, vital, pedestrian-oriented traditional village that can support a variety of residential, commercial, office, and civic uses. The design regulations are specific for the Citrus Park Village community to ensure compatibility with the community plan. The proposed commercial use meets many of the design requirements as is practical and within reason for the site, and therefore meets the intent of the Citrus Park Village Community Plan. Based upon those considerations, Planning Commission staff finds the proposed plan development consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County, subject to the conditions proposed by Development Services staff. Thank you.
Thank you very much. And with that, we'll hear from the zoning hearing master's recommended summary.
The zoning hearing master considered the request for rezoning of approximately 0.59 acres from the Citrus Park Village subarea G6 to planned development in order to permit the development of an automated car wash. The zoning hearing master stated that the applicant has requested waivers to the Citrus Park Village LDC standards regarding block pattern and the maximum impervious surface ratio. The applicant stated that the property is small, irregularly shaped, and reduced in size due to improvements to Gun Highway, thereby making compliance with the block pattern and maximum impervious surface standards unattainable. The zoning hearing master found that these waivers are justified as the project demonstrates compliance to the greatest extent possible with the significant number of Citrus Park design standards listed in the LDC. The Planning Commission staff, as you've heard, has found the request to be compatible with the surrounding land uses and consistent with the comprehensive plan. The zoning hearing master noted that some letters in opposition were submitted into the record prior to the zoning hearing master hearing. The concerns raised included the impact of the project on transportation, proximity of nearby schools, tree preservation, and possible impacts to wetlands. County transportation staff reviewed the project and did not have any objection to the rezoning request. The project will be required to comply with the applicable county regulations pertaining to any tree removal. According to the staff report, EPC has found that there are not wetlands on the subject property. There was no testimony in opposition at the zoning hearing master hearing. An automated car wash is a permitted use in the existing Citrus Park Village G6 zoning district. The zoning hearing master stated that the area surrounding the project is developed with a mix of residential and commercial land uses, and the proposed car wash will be a compatible land use given this development pattern. The zoning hearing master recommended approval of the plan development rezoning request and concluded its hearing.
Thank you very much. With that, we'll open it up for board discussion or a motion.
Move
I see,
approval.
and I see Commissioner Hagan has got his hand raised.
Oh.
Thank you, Madam Chair. I was just going to be brief and just say, if you're familiar with Woody's, you know it's not your typical car wash. It's an attractive and upscale operation. That would be an excellent addition to the area. So it has all recommendations for approval. So I believe I heard Commissioner Kent make a motion, but I'll second that if there's a motion on the floor. But happy to support it, and it'll be a welcome addition to the area.
Thank you very much. I'm not seeing any other discussion. We have a motion by Commissioner Kemp, a second by Commissioner Hagan. Please take a roll call vote.
Overman?
Yes.
Cohen?
Yes.
Hagan?
Yes.
Kemp?
Yes.
Myers?
Yes.
Smith?
Yes.
White?
Yes.
Motion carries 7-0.
Thank you very much. We'll move on to F5.
The next item is agenda item F5 is rezoning standard 22-0580. The 11.51 acre parcels on the west side of County Road 579, 240 feet south of Pruitt Road. The request is rezoned from RSC4 MH and AS1 to RSC4 with a mobile home overlay. This is in a Res 4 plan category, but is in the rural service area. Therefore, minimum lot size will be dictated by the minimum lot size for a septic, which is a half acre. This was found approval by staff, the Planning Commission, and the hearing officer. It is on this portion of the agenda. There was, because it's an increase in density in the rural service area, staff is available for any questions. Thank you.
Thank you very much. We have time set aside for the applicant. However, I do not see an applicant signed up to speak. Is there someone here that wishes to speak to that item? from the applicant team?
Sorry, good morning. Isabel Albert with Half Associates, 1000 North Ashley Drive, Suite 900. This is a very simple case. I'm here if you have any questions. I have nothing further to add.
Excellent, thank you very much. With that, we'll open it up for any proponent or opponent parties of record that may be in the room. I don't see anyone signed up.
There's no one in the room.
Excellent, thank you very much. And with that, assuming no need for rebuttal, we have Planning Commission staff.
Thank you. Melissa Leinhardt, Planning Commission staff. The subject property is located within the residential 4 future land use category. The site is in the rural area and is located within the limits of the Thenodisassa Community Plan. The intent of the residential 4 future land use category is for areas that are suitable for low density residential development. On the proposed 11.49 acre site, up to 45 dwelling units could be considered. However, lots on septic must have at least half of an acre. Therefore, the yield of lots on the site will not reach the maximum allowed based on that standard. For future land use element policy 9.2, developments must meet or exceed the requirements of all land development code regulations as established and adopted by Hillsborough County. Per the one water section of the comprehensive plan, and any extension, connection, or utilization of water or wastewater systems in the rural area are considered on a limited basis if they meet specific exemptions as outlined in the Land Development Code. In addition, new development is responsible for infrastructure and services outside of the urban service area. The site does not meet the specific exemptions and must provide septic system connections for the proposed new residential development in the rural area. While the submitted narrative states that 10,000 square foot lots or half-acre lots per the LDC, the applicant in the rural area is required to build half-acre lots at a minimum. Compliance with this requirement is essential to the proposed rezoning being consistent with future land use element policy 9.2 and the one water sections objective 4.3 and policies 4.3.2 and 4.3.3. For future land use element objective 4, the intent of the rural area is to provide areas for large lot, low density rural residential or agricultural uses. Future land use element policies 16.1, 16.2, and 16.3 require new development to be compatible with surrounding uses. Single-family residential and vacant land uses surround the site. Immediately south of the site are agricultural uses. Further east and west of the site are mobile home parks. The proposed development is for single-family residential and mobile home lots, which is consistent with the development pattern in the area. The subject site is located within the limits of the Thenodisassa Community Plan, and the applicant's proposal for residential on half-acre lots on septic meets the community plan intent to protect the area's rural character and restricts central water and sewer services within the rural service area. Based upon those considerations, Planning Commission staff finds the zoning consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County. Thank you.
Thank you very much. We have the zoning hearing master's recommended summary. That is not easy to say quickly. Thank you.
The zoning hearing master is requesting, the applicant is requesting a rezoning to the RSC4 MH zoning district. The zoning hearing master stated that the property is 11.51 acres in size, currently zoned AS1 and RSC4, designated residential 4 on the comprehensive plan. The property is located within the rural service area and the Thenodisassa community planning area. The zoning hearing master noted that the proposed minimum lot size is 1/2 acre, as the property proposes to utilize private well and septic tanks. As you've heard, the Planning Commission staff has found the request to be compatible with the surrounding area and consistent with numerous policies regarding compatibility with the surrounding properties. The zoning hearing master found that the request for the RSC4 MH mobile home zoning district on the subject property is appropriate given the existing zoning districts which permit mobile homes and 1/2 acre lot sizes, given the proposed use of septic tanks. The zoning hearing master concluded that the request is compatible with the surrounding zoning districts in the residential 4 future land use category and recommended approval.
Thank you very much. I see Commissioner Hagan has his hand raised, but it may have been from the prior item. But with that, I'll open it up for board discussion or motion or consideration. Do I have a motion? Oh, I'm sorry, I didn't see your, Commissioner Smith, you're recognized.
Does Commissioner Hagan want to speak?
I don't hear him returning, but.
In his district, okay. I'd like to ask Planning Commission staff, Ms. Leinhardt, if we could look at that page 3 of the backup that shows the comprehensive plan designations out here. You know, I'm just confused about why we have such a large area of Res 4 designation in the comp plan outside the urban service area, when, you know, it's not even possible to have 4 per acre out there, as was explained. They can only have maximum 2 per acre in order to have the drainage field that would be required for each and every septic tank that would be put out here. So how did this ever get Res 4? Ms. Leinhardt?
Thank you, Commissioner Smith. I'd be happy to help. Melissa Leinhardt, for the record, Planning Commission staff. We had the same question when this application came in, seeing that this is residential 4 in the rural area and not the urban service area. Without the detailed history behind, you know, each parcel and why something is in the urban service area or in the rural area, and the future land use category associated with it is really unknown in a lot of circumstances. With this one, the deduction that we made as staff was that it was designated that in order to recognize the existing development pattern. But beyond that, it is unknown why there's a larger swath of residential 4 in the rural area. But it was noted by staff as well as unusual.
If I could follow up, so could we look at the page 3 in the backup here so you can see there's really a large area, not just this site, but a large area that is designated the same color. I assume that's Res 4 in the comprehensive plan. Ms. Leinhardt, are you saying that I mean, your deduction is that was done to recognize the pre-existing development pattern, so there already was 4 per acre, even though you can't get 4 per acre without, if you're on well and septic, because you'd have to have each one. I mean, how could there be a pre-existing development pattern of 4 per acre in an area where you would need half an acre for each and every septic tank? I'm just not getting it.
That is a very good point. Again, Melissa Leinhardt, for the record. What I meant by pre-existing development pattern is the existing land uses that are there today, not necessarily why it was designated as residential 4. I mean, there are some smaller lots to the west and then a little bit to the east and the north and the south that also have the residential 4. And these 2 parcels are sort of sandwiched in between those, and I say smaller lots, but smaller for the rural area. So that is my guess, is to connect that logically with the areas around it where there were smaller lots, that at the time it felt that it made sense to designate them as the same, to recognize that existing development pattern that surrounds them. Does that make sense?
Okay, not really, but what if, I mean, why aren't we zoning this to the level the highest level they can achieve, 2 per acre? You know, my concern is we end up with these kind of outdated zoning designations, comp plan designations that were based on stuff before we knew better. And then we keep chasing them, you know, throwing more entitlements after entitlements we don't even know what they're doing there, and more than is needed. But then, you know, that just ratchets up what's possible in the future here, and then they go back saying, well, we've got the 4 per acre zoning. Now we want, I don't know what else. It just seems like we're giving away more than they can even use, and without even I don't understand why we should. So, you know, I'm just, unless I hear any other better argument for why we should give them more density than they can use outside the rural area. I asking for trouble in my book that for people to come back piling on this. I don't see a reason to support it. Thank you.
Commissioner Kemp, you're recognized.
Thank you for raising this, Commissioner Smith. When I was briefed on this, it was also, I just didn't understand how it occurred this way, but, you know, sometimes we do deal with these anomalies that are just make no sense at all. But I'm thinking now, I mean, I just didn't think about how you get out of it, but right now we are redesignating this. I think it makes a lot of sense at this point when we're being asked for this. And I'm just, you know, I just wonder if, for instance, I'm wondering if this same application could be continued if the applicant, if the applicant could be asked to, you know, accept a Res 2 designation, or how, if the applicant would be agreeable, or how that might work?
Commissioners, we could certainly have that discussion with the applicant. As stated, any which way, the minimum lot size here will be half acre. It may be that they're requesting Res 4 to give them flexibility on the development setback standards, but we certainly could have that discussion with the applicant with a continuance to pursue whether a different zoning district would.
I just think that makes so much sense. So it would be a continuance you would recommend rather than like a remand or anything?
I think I would suggest a continuance because it's a, you know, this is a standard zoning district, so we're not dealing really with new conditions, and if they would change the zoning request.
And then maybe they could ask for that waiver if they wanted that waiver on the buffering or whatever else it is. That's the issue that you mentioned.
I think that, yeah, we'd like to have that conversation. If it's a standard zoning district, it will be, that's the district they have, and it comes with those standards. So it would be, I think with a continuance, we could have a opportunity to discuss that.
It would be really good, I think, to clean this up. So I'll make a motion for a continuance in light of the issues that we've discussed
So we have a motion to continue by Commissioner Kemp and a second by Commissioner Smith. Is there any other further discussion? I want to go ahead and take a vote, but then I'd like to ask a question after we get through that. So.
Overman?
Yes.
Just, I'm sorry, announce it.
Yeah, oh, that's right, you need a date. I'm sorry.
August 25th at, I'm sorry. Yes, August 25th, Thursday, at 9 a.m.
Excellent, thank you very much. So we have a motion to continue to August 25th by Commissioner Kemp and a second by Commissioner Smith. Not seeing any other discussion at this point. Please take a roll call vote.
Overman?
Yes.
Cohen?
Yes.
Hagan?
Yes.
Kemp?
Yes.
Myers?
Yes.
Smith?
Yes.
White?
Yes.
Motion carried 7-0.
To that point, I'd like to just ask a quick question. You know, you brought up a very good point. I'm looking at the map all around that, and there are several other properties. One looks like it's a CG, but the rest look like it's all Res 4 in an area that doesn't make sense. So there's several contiguous properties that do not look like they're developed. And instead of running into this freight train, what are our options at this point? Because if we cannot determine how it got to Res 4 in the record anywhere, I'm curious about how it shows Res 4 on the surrounding lots beyond this particular project. Can maybe the planning commission give us some guidelines? Because there are two very large lots, 3 very large lots, actually, south of this particular property. I can't tell if one is actually CG or not, but it doesn't appear to be zoned that way.
Just
there
as a
some
matter,
guidance
Commissioner Smith requested the map several times. I had the map kind of in my head, but it might help to have the, if we could get that map up for others to understand, might be helpful.
Page 2-3 of page 74.
Yes, the future land use map should be in your backup as part of the last page of the Planning Commission consistency report. But to address your concern or question, Commissioner Overman, with the continuance, I would ask Ms. Lundgren how much I can contribute that's extra beyond the record that was established. But if there's some research that needs to be done on our end, I can dig a little deeper to find out if there's a better explanation for why there's residential 4 in such a great number in this exact location in the rural area. What I was saying before about the lot sizes, if you look like to the southwest, for instance, those lots are actually pretty small for the rural area. They're about a ½ acre in size. And some even go down to about a ¼ acre surrounding the subject property, and then a little bit further south, and then of course east. Across Mango. So I'm wondering if this larger swath was just to recognize those smaller lots that pre-existed the plan, but then encompass the larger pieces in between, so it wasn't as a hodgepodge of an area, and it was more coherent and consistent. But again, I can research that further, but I would ask Ms. Lundgren how much I could contribute to the record beyond what was established at the zoning hearing master.
At this point, if I may, this is a record-limited request, so any additional research would go beyond what's already in the record. If the board was inclined to, after considering further information on the continuance, if there's still a need to look into that, remand may be possible, but it's...
Right.
This is a separate request. We're already disposed of the item to continue it, but my question is...
If it's in the context of if the information comes back in the context of that zoning application, that is an issue. But if it was a separate item, separate evaluation or report from the Planning Commission, that would be
And that
different.
is what I'm asking for, is a separate consideration of the properties surrounding that particular item, and how, if there's an opportunity to discern how we ended up with the level of development that isn't possible in that area, and whether or not it should be considered. I understand there's rules about entitlements, but I'm trying to understand, if there's a way to find in the other properties to avoid running into this circumstance going forward. So. But with that, we'll go on to the Commissioner Cohen.
If I may, I just want to ask one question after listening to this whole discussion. It seems to me, I'm sort of shocked that this would be found approvable and consistent, given that what's being asked for is impossible under the standard. I'm not trying to find fault necessarily with the decision making, but you would think that would immediately cause it to be in the category of not allowed, and for us to override that in order to make a change, as opposed to it being given 3 stamps of approval. That doesn't seem to make a lot of sense.
So our look at this was whether a 10,000 square foot lot would be appropriate for the area, and that's what the Res 4 district equates to. In trying to do, if you look at the site and do the math and say so many acres or 4 units per acre, it's not going to come out to that number. But our evaluation on it was relative to that lot size, and we know that it would be exceeding that lot size.
So your analysis was about the individual parcel as opposed to the larger policy implication?
Yes, it's you know, what was the maximum density that the comprehensive plan category could support? Would a Res 4 be consistent with that? And the Res 4, again, 10,000 square foot lot is a minimum lot size. We know it would have to be minimum of half acre, over 20,000 square feet per lot. So that was our thought. Our thought behind the review, understand the questions, understand the history, and as part of looking at the future land use map, we'll also look at the history of the minimum half-acre lot size on septic, because that may not have always been the case, and it may not have been a requirement when the future land use map was adopted. So that may have been a changed circumstance since the Res 4 was landed there. And we'll
Got it.
look at that.
Thank you. Thank you for that.
And that's why I asked for the research, not necessarily a ruling, just to help us understand how we got here. So if there is continuing opportunities to get here that we don't want to do, that we can probably get that resolved, and it'll help not only applicants in the future, but it'll also help us in making sure that we're not approving something that may not be appropriate for the area. So that's why I asked. Okay, well, thank you. So have we taken a vote on F5? I've lost my place, I'm sorry. Yes, okay. Next item, please. That is F6.
F6 was continued as per the changes to the agenda.
We've
So the
approved
next
it for
item-
continuance, yeah.
So the next item then is item F7. This is a rezoning standard 22-0702. It's a rezoning from ASC1 to commercial neighborhood with restrictions. The parcel is located in the Palm River community, north side of Hartford Road. The request, again, as I stated, was seen was restrictions. The restrictions deal with specifically limiting the use to an outdoor and indoor venue, banquet, reception use facility. The applicant has also offered up operating hour restrictions and also to maintain existing fencing. I believe the applicant also will be proposing an additional restriction as part of their presentation regarding amplified music and speakers for the project. Staff reviewed this and found this inconsistent with the surrounding development pattern, given the residential zonings within the immediate area. The Planning Commission found it inconsistent. It does not meet locational criteria and needs a waiver to location criteria. And the hearing officer recommended denial. Available for any questions. Thank you.
Thank you very much. With that, we'll hear from the applicant. We have 10 minutes.
Good morning, Madam Chair. Todd Pressman, 202nd Avenue South, number 451, St. Petersburg. I'm here this morning with Mr. and Mrs. Soto, who operate or help operate the family business. This is standard rezoning standard 0702, ASC 1 to CN. Next slide, please. Located in the greater Palm River area. Next slide, please. This is the location. Next slide, please. And is shown by the property appraiser is here. Next slide, please. In terms of immediate surrounding uses, we have a school to the north, but you see that there's Bulk Express, Premier Trailer Leasing, Eagle Transport Corp., S&S Freight, which front on the subject site. Next slide, please. Looking at zoning, it's all manufacturing zoning and CI manufacturing further down the street on Hartford. Next slide, please. Future land use categories, SMU 6 and public is next door. Light industrial is the entire future land use category opposite, and pretty much everything to the west, I believe that is, and an SMU 6. Next slide, please. So this is a 4.61 acre lot seeking ASC 1 to CNR. And we have a number of restrictions. The first is restricted to outdoor and indoor venue, banquet, reception use facilities. So we are restricting to a specific use that is existing. Again, that is an outdoor, indoor venue, banquet, reception use facility. Second restriction is events only on Friday, Saturday, and Sunday. The Friday events are only after school hours. Next slide, please. The existing fence which surrounds the site now must remain in place. The events are only between 4 p.m. and midnight. other than setting up and cleaning up. Now, we have added a fifth condition after hearing from residents and seeing the hearing master report, which is that any music, including amplified music or speakers, are required to be completely enclosed within the interior of the building, and any openings such as doors and windows must be closed. So as we have spoken with neighbors and heard from residents, and again, the hearing officer, we've included this condition to address everything that we possibly can so the Sotos can be good neighbors. Next slide, please. The main exit to the school is north on, I believe that's 30th. Next slide, please. So that's a blow up of the school. Virtually all the activity of school is up towards 36th Avenue. As you can see, the school roundabout and the frontage of the school towards 36. Next slide, please. And per the wetlands, the particular site under your consideration is abutting significant wetlands as a great buffer. Next slide, please. So those wetlands are abutting the site and provide a good buffer. Next slide, please. Budding neighbor support. Next slide, please. So we do have on record the neighbor to the north abutting and the neighbor on the side, as you can see there, both have support. Next slide, please. And this is one letter from Mr. Reyes. And next slide, please. And from the other Reyes as well. Next slide, please. So locational waiver is addressed by geographical and operational elements that provide compatibility. There's very good buffering and fencing, buffering a lot natural, let alone the wide open spaces. The restrictions, use of infrequent use of the site as is, and as we indicated, we've added conditions to that. The orientation of the school, the widespread nature of the area, and the intensive uses and zoning that are immediately located virtually across the street and nearby. Next slide, please. So staff's main concern has been compatibility with residential to the west and north specifically. We've documented for you that support from those direct property owners. The second is noise emanating from the site of the school. So we documented no school hour activity, and we've added, since the zoning hearing master, all music must be interior to the building. Next slide, please. When you look at the zoning hearing master report, her comments really come down to one point, which is the last paragraph, where she notes the proposed restrictions do not address the noise generated by the parties, events, of the facilities, but only limit start and stop times. So we took very clear direction from that, and again, talking with the neighbors to add that condition. So we felt that we could address the condition or address the concerns raised by the neighbors. With that, I'd like to ask Mr. and Mrs. So to make a couple of comments, if I may, Madam Chair.
Sure, you still have 5 minutes.
Good morning. I'm not sure if I need to be sworn in or not. My name is Charles Perello, 3105 North McDill Avenue, Tampa.
Has he been sworn?
I have not sworn.
No. Could you please swear him in, please?
Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Good morning. I'm basically here representing the family. I'm the son-in-law of Pedro Rodriguez from the Rodriguez property. Today, we're basically just asking for your help as we're really not looking to kind of publicize this as a venue. Basically, right now, it's just been a word of mouth that we've been approached from family parties where people that have come to the parties, birthdays, whether it be baby showers, have asked us if they could rent it from us as a family. Her father has been approached in prior years for fundraisers. He's opened the doors for the sheriff's office, the TGA nurses, Charlie Miranda, and friends who have kids that have illnesses have approached us, and we have done fundraisers there for them. But there's never been a penny collected. Our family's always been about giving back and opening up ourselves to the communities. Mr. Rodriguez has been a hard worker all his life, owning a business on Florida Avenue, a body shop that now has taken a toll on his body. So we do celebrations. I'm very involved in youth sports, and I do celebrations there for the either championships or the kids' business. The kids' championships. So we opened the door for them, and one of our biggest celebrations, ironically, was one that where the county presented to us a key to the county for our youth team who had won many championships. Recently, because what we're looking to do is really just use this opportunity to raise some income to supplement the family who's been ill. Her father just a 4-month bout with COVID. We just took him out of the hospital because we cannot afford the hospital stay anymore, and we want to use the assets that they've gained in their lifetime to help them supplement their income and help pay for these medical bills with her mother, who's also had some bypass surgeries and issues like that. So we're just asking you to please approve the zoning, as our goal is not to disturb our neighbors, but to help my in-laws with a better quality of life in their latter years. Thank you.
My name is Juana Rodriguez Soto. We're just here to make an effort to get this rezoned properly and just help the family business to help my parents. I did meet with the neighbors, and we discussed some of her issues, which was the music, and we understand. And so we're making every effort to correct that. We're going to have all the music inside, as Mr. Pressman stated earlier. And we're just there to work with the neighborhood. We've had the property for over 50 years, never had a problem. If it would have been approached earlier, we would have taken care of it. Initially, there was some zoning issues, which we were not aware. I talked to Officer Sadler with code enforcement and the fire department. They came out and said everything was up to code. We applied for the business license, turning the property into a clubhouse use. In November of this year, Mr. Sadler called me and said it would have to be rezoned, and that's when we started the application process. Thank you.
Okay, thank you. Is that all of the applicants' presentations at this point?
Yes, ma'am.
Okay, thank you very much. With that, we can hear any opponent or any proponent testimony.
We do not have anyone in the room nor online.
All right, with that one, then we'll move on to the Planning Commission.
Yes, thank you. Melissa Leinhardt, Planning Commission staff. The subject property is located within the residential 6 future land use category. The site is located in the urban service area and also within the limits of the Greater Palm River Community Plan. The applicant is requesting to rezone the subject site from agricultural single-family conventional 1 to commercial neighborhood restricted to permit an indoor and outdoor venue, banquet, and reception facility. Neighborhood serving commercial uses are subject to commercial locational criteria in the residential 6 future land use category. The proposed rezoning does not meet locational criteria as it is not within a qualifying distance from an identified commercial node. The applicant has submitted a waiver request for review as permitted by future land use element policy 22.8, which states that the use is compatible with the neighboring school due to wetlands acting as a buffer and distance from the school access. The applicant also contends that the proposed restrictions would mitigate for the proposed use. The applicant also notes the presence of higher intensity uses to the south of the subject site. Planning Commission staff has read the waiver request and note that there are higher intensity uses to the south that are in the light industrial future land use category where such uses are anticipated. Moreover, per policy 22.7 of the future land use element, commercial locational criteria are not the only factors in granting approval, and the site is located within the Greater Palm River Community Plan, which has identified specific nodes for compatible commercial uses. The site is not located at one of those nodes, and Planning Commission staff does not support the waiver and advises that the board not grant a waiver to commercial locational criteria. Objective 16 and its accompanying policies in the future land use element require the protection of established neighborhoods and that the proposed development be compatible with the development pattern of the surrounding area. The applicant has proposed restricting the commercial neighborhood uses to just the indoor-outdoor event venue and will limit the hours of operation. However, according to policy 16.10, compatibility does not mean the same as. Rather, it refers to the sensitivity of development proposals in maintaining the character of existing development. The subject site is located directly south of single-family residential uses and has not demonstrated how they will mitigate for any noise emanating from the outdoor events, which is inconsistent with policy direction. The proposed rezoning is inconsistent with the Greater Palm River Area Community Plan under Goal 5A, 14E, and F. The Greater Palm River Area Community Plan has identified specific nodes within its boundaries where it would like to see compatible commercial, and the subject site is not located at any one of those nodes and therefore does not meet the intent of the community plan. Based upon those considerations, Planning Commission staff finds the proposed rezoning inconsistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County. Thank you.
Thank you. We'll hear from
Excuse me, Madam Chair.
Yes?
We do have someone in the room that is in opposition.
Oh, okay. All right. I did not give that person an opportunity to speak because I did not realize there was anybody else there. So there is 10 minutes set aside for proponent and opponent testimony. If we have someone that has been sworn in that would like to speak as a proponent or opponent, please approach the podium and not identify yourself.
Yes, my name is Thelma Fernandez, and I live at 6610 36th Avenue South, Tampa, Florida. We're just north of this venue. I've spoken to the family in length, and I've spoken to the neighbors in the neighborhood. Several of them are still in opposition. I've spoken to them. I really do think that they have a good faith effort, that they are going to try to work with the neighbors in the neighborhood, and I'm not as staunchly opposed to it as I was. They've said they're going to put up sound barriers, they're going to keep the music inside, which is mainly the big issue, the music. They don't have enough traffic because they're not a venue every weekend. It's like every other week or maybe twice a month, something like that. So the traffic doesn't really impede into the neighborhood like some of the others do. On 70th Street, we have a wedding venue. It's close to Causeway Boulevard. They, in turn, do impede traffic into the neighborhood, but their music is over with at 9 o'clock. If these people would keep their music off at 10 o'clock on, the neighbors wouldn't be so upset about it. We have a lot of older people in the neighborhood that have been there for many years, and being able to rest is a big problem. A lot of the younger ones, because the people have been there, like Mr. Cook, who was here the other week, he's in his 80s. My mother-in-law just passed away. She was in her she was 96. So the younger ones coming in the neighborhood that are buying buying the houses, they're more concerned about their children. They're more concerned about being able to get them to bed. The ones that live in the neighborhood, there's a Spanish-English problem, and they're like, well, do we complain? Do we not? They've been assured, we've talked to them all, and they've said that they're willing to try. But a lot of the younger ones are like, that have been here in the neighborhood, like the Transus, the Romanos, some of the others are like, well, how can we be assured they're really going to do this? They've had this property for over 40, 50 years. They've never given us any thought before. What's going to say they're going to follow through with this? And I've told them that this is not the original. The original owner is still there and still controls the property, but these are the children, and they're going to work with us to make this happen. I'm not as opposed to it as I was, but I still have my reservations. And the neighbors, and the reason why I have reservations is the neighbors have reservations. They're not sure if they want this, but there needs to be something in there that this does not turn into another hurricane ranch. We don't need that in our neighborhood. So that's their big complaint. So if we can put restrictions with the noise, and I will say since their last hearing, there has been no problem with noise, and they have had parties there. And, you know, there's been no problem. So I really do think that they're going to comply and that they're really going to do what they say they're going to. They just need to be given the chance, even though a lot of the neighbors are still against it. So I'm kind of I don't know what would be the best solution. As long as they stop by 10 o'clock and as long as they heed to the noise ordinances that they're putting, you know, that they're suggesting, and I think it'll be fine. But we'll just have to wait and see. Thank you.
Thank you. Are there any other opponents or proponents that wish to speak to this item? Okay.
No
seeing-
one standing in the room.
Okay, great. Thank you very much. Ms. Lundgren?
The zoning hearing master considered the applicant's request for rezoning to the commercial neighborhood restricted zoning district. The property is 4.61 acres and currently zoned ASC 1, designated residential 6 by the comprehensive plan. The applicant's requested rezoning to the commercial neighborhood restricted zoning district will be subject to several conditions which the applicant placed in the record and previously explained during the applicant presentation. The property owner testified that the indoor-outdoor party event facility has been in operation for several years. Previously, the property was signed for conducting a land use that is not permitted in the existing ASC 1 zoning district. So this rezoning is an effort to come into compliance. Planning Commission staff, as you heard, has stated its non-support of the application. Development Services staff also does not support the rezoning as the facility would adversely impact the adjacent residential to the north and west, and found that the facility is inconsistent with the character of the area on the north side of Hartford Street. The zoning hearing master stated that 2 letters of support were filed prior to the hearing, signed by the adjacent property owner to the north and a resident on 36th Street northwest of the subject property. The zoning hearing master noted that 2 neighbors spoke in opposition at the zoning hearing master hearing. These neighbors live on 36th Street, and the neighbors testified that the noise generated by the parties and events keep the neighbors awake in the night. Testimony also included reports of police being called to the facility. The property owner responded to the testimony in opposition by stating that the family is on site at the conclusion of the parties to ensure that the music is turned off at midnight. The zoning hearing master concluded that the proposed restrictions that the applicant has offered do not address the noise generated by the parties and events at the facility, but rather only limit the start and stop times of the events. The zoning hearing master's finding was that the request for the C&R zoning district on this subject property is inappropriate given the existing agricultural, residential, and institutional uses surrounding the subject property. The zoning hearing master concluded that the request is inconsistent with the code and the comprehensive plan and recommended denial.
Thank you. With that, I'll open it up for board discussion. Commissioner Kemp, you're recognized.
Madam Chair, as the applicant, can I respond, please?
As a rebuttal, I didn't offer him the rebuttal. After the,
I'm sorry, I think the party of record appearing after Planning Commission that got off track, but I would remind you that yes, the applicant is entitled to 5 minutes of rebuttal.
right. That's why I failed to offer him
Yes.
the 5 minutes of rebuttal after the previous opponent and proponent. So I apologize for that in error. Am I permitted to offer him his
Yes.
time for rebuttal? Thank you. Sir, you're welcome to offer 5 minutes of rebuttal if that's your choice.
Thank you, Madam Chair. I'll make it as quick as I can. I'd like to thank Ms. Fernandez, who spoke. I'm glad we were able to address her concerns. To reiterate, this site has very intensive zoning and future land use immediately surrounding it. And the owners to the north abutting and to the west abutting are on record as supporting it. I did receive some communication from the school. They asked me about it. That was the last I heard. We've received no opposition from them. Ms. Fernandez today indicated 11 p.m. would be a limit for her and the neighbors, and we're happy to meet that as an additional condition. Again, the Sotos are happy to work with the area neighbors in any way possible. And then finally, just so you have the lay of the land, the site is here. Ms. Fernandez is located up here, which is per Google, 1,264 feet away. So between the school, between the two uses. So I wanted to just give you a little bit lay of the land, that she's not an abutting owner or really a nearby neighbor, but we're still addressing any concerns anyone has. Thank you, Madam Chair.
Thank you. With that, we'll open it up for board discussion. Commissioner Kemp, you're recognized.
And I had pushed my button before we had the end opposition or support, whatever, the last speaker come and then the rebuttal. I'd heard nothing before that, but let me, just in light of the new information, and I thought it was worth repeating, actually, for anyone who, for the record, the restrictions that they had agreed to, which I guess was, can you just be precise and address them directly?
Yes, the restrictions that the applicant has agreed to is, number one, the use is restricted to an outdoor and indoor venue / banquet / reception use facility. Restriction 2, events on the property will only occur on Friday, Saturday, and Sunday. Friday events would only occur after school hours. Number 3, the existing fence of which surrounds the entire property must remain in place. Restriction 4, events are between 4 p.m. and midnight, and I'll note that I believe Mr. Pressman just verbally changed that to 11 p.m., other than setting up the event and cleaning up the event. And the 5th restriction, and this was just sent and offered today, sent to the board today, any music, including amplified music / speakers, are required to be completely enclosed within the interior of the building, and any openings such as windows or doors must be closed. And those are the restrictions that the applicant has offered in connection with this request.
Thank you for repeating those. And I think the concerns we heard, what I heard was that no one was particularly concerned about the traffic to the spot, that the music was the concern, that there has been some working with those there for the past year about that, and now we have a condition that says 11 at night, amplified music within the building. We also have, for instance, because they may not always own this property, it may not always be what this, but if for instance, a worst case scenario developed with regards to this, we have code enforcement that does noise. Can you just explain?
Yes, so these restrictions would be enforceable as same way as zoning conditions would be. This is a little bit maybe easier than a noise level because it simply has a stop time for the events and a control situation for the music, that it be within the enclosed building. So those are enforceable restrictions in the event that's necessary.
And, I think I'll just say, and I appreciate the circumstances around here, but I saw, there's a lot of light industrial. The closest neighbors to the west of the property and to the north, where there seemed to be on the map very little else in terms of residents, came in support of this. The school is actually a distance away, but these events, because they're restricted to Friday, Saturday, and Friday after school, will not come in conflict with any of the school times or events. And I guess I've been very interested, as I've said before, in seeing kind of back to what it was, times when we had kind of organic growth of neighborhood commercial types of businesses and uses, because I think that is what ultimately gets us to neighborhoods or areas that work, all the things we talk about with trip capture and, not having to go far. For instance, for this type of service if you wanted it in your area. So I'm just, I'll make the motion in support of this, and those are the reasons. I actually generally I understand where the objections and fears are, because I have restaurants around me where I live. I have different commercial entities just blocks from me. So I understand the concerns and want to not, need to address those conflicts. But I'll make a motion in support.
Second.
We have a motion by Commissioner Kemp, a second by Commissioner Myers. Commissioner Smith, you're recognized.
Just very briefly want to thank the representative of the community and the neighborhood who came forward and helped us understand and refine the issues and the conditions, and thank the applicant for continuing to work up to the last minute with the neighborhood's concerns on what I think will be good, workable, enforceable conditions. As Commissioner Kemp points out, we have to always be mindful that even though these are very motivated applicants who really want to do the right thing and work with the neighborhood, we have to put conditions on so that when this property, if ever changes hands, that the next owner will also be conditioned in the same way, and I think that's been achieved here. So thanks to everybody working together.
Good. I had a couple of questions, but I would like to support the motion as well. Currently, the condition is of the building is the size that it is, and it's a venue banquet that actually requires a for example, if you want to have a wedding, you have to actually hire a caterer that has a liquor license, because you don't have a liquor license as part of the property. Is that correct?
Yes, currently they do not have any alcoholic beverage approval for the site.
Okay, but if they are doing a banquet venue and you hire a caterer that has a license, would they be able to actually accommodate that at this location? I think the answer is yes. I'm getting verification of that.
Yeah, we would generally will have a requirement for a alcoholic beverage license if there's going to be public sale or consumption of alcohol on the premises. So we have to look at the circumstances of how they're going to operate to see whether that would be required for this particular use. And we would look at that, as part of their, if assuming this zoning is approved, they would still need to come through and permit the development of the site to bring it up to current operational standards for the use that's being approved. And we would look at that alcoholic sales element as part of that.
Well, I'm not saying that, every venue that has an event, a venue that has an event in it may not have a liquor license, but if they're catering it, the caterer brings the license associated with it. And I'm not certain that it requires a liquor license on that property. It has to be associated with the venue being able to hire a caterer. And in this particular case, that's specifically what this type of venue permits, correct?
That is the type of operation that's being proposed for the venue. Yes.
Exactly.
And it's a difference potentially a difference between a state license and our zoning permit.
That's why I'm asking the question, because it's, it is next to a school. We have a series of rules associated with that. It isn't necessarily going to be at this time a purpose of having alcohol sales there, but if you are doing banquets and weddings and those kinds of things at this location, which is what this will ultimately, whether these individuals are owning it or running it or not, what's possible, correct?
Yes.
Okay. So I'm willing to support the program as it is now, but if the building were to be bigger than it is, and we're able to bring a licensed caterer in for alcohol sales, it could end up being a very different scenario than what we're proposing or what we're approving today. And I'm not to say that we wouldn't support what's being proposed today, but those restrictions need to be very clear of the intent of this particular project. So I just as a word of warning, that I think there's a great opportunity for creating a community space. If this were a community center, or a library or whatever, we wouldn't have a hesitation at all. But because it does have the potential of being something different in the future, I think there is a good reason to be cautious and make sure that those conditions are maintained. So thank you very much. Any other comments? I'm seeing none. We have a motion on the floor for Commissioner Kemp and a second by Commissioner Smith, or I'm sorry, Myers? Okay. And with that, please take a roll call vote.
Overman,
Yes.
Cohen,
Yes.
Hagan,
Yes.
Kemp,
Yes.
Myers,
Yes.
Smith,
Yes.
White.
Yes.
Motion carried 7-0.
Excellent, thank you very much. Next items are G1 and B together. I think if we could cover this quickly and get to that, we might be able to get out of here by 1 o'clock.
Yes, the next items are G1A and G1B. G1A is a vacate petition. That'll be real estate services will provide a presentation on that. G1B is a related plat that would otherwise been on consent if not needed to be acted on after final action on G1A. Thank you.
Is that the extent of the introduction by staff?
I believe there'll be a brief presentation on the vacating request for G1A.
Okay, great.
Yes, good afternoon, Commissioners. For the record, Carrie Allen, Facilities Management and Real Estate Services. I'm going to be presenting the vacating item. G1A, this is vacate ID V200018. This is a petition by Lennar Homes LLC and Crestview Lake Community Association, Inc. to vacate and replace a platted public pump station within the plat of Rivercrest Lakes as recorded in Plat Book 134, page 180 of the Public Records of Hillsborough County. After the plat of Rivercrest Lakes was approved and recorded, the petitioners constructed the public pump station outside of Track Z, which is the platted pump station site. In order to correct the location of the public pump station site, the existing platted pump station must be vacated and the petitioners must dedicate a new pump station site. The proposed vacate area is located north of Rodine Road, east of US Highway 301, and west of Balm Riverview Road in Riverview. And the vacate area consists of approximately 7,000 square feet. Reviewing departments, agencies, and utility providers have raised no objections to the vacate and replacement of the platted public pump station. However, the consent of the Water Resources Department is conditioned upon acceptance of the water wastewater easement, which provides the county with the right to maintain the public pump station and the existing public force main and water main adjacent to the pump station. As a related item to this vacating, the property owner has submitted a replat of the subject area, which dedicates a new public pump station site. Staff recommends approval of this petition request and acceptance of the water wastewater easement. Thank you.
Thank you very much. And since we are taking G1A and B together, is there a report on B, or was that a combined presentation?
It's combined. B is a replat to reestablish the new pump station line.
That's what I didn't want to assume, but
Yes,
that's
ma'am.
what I thought. Okay, great. Thank you very much. This is a public hearing, and so I have an opportunity for anyone that would like to speak to this item on G1A and or B. I don't see anyone signed up to speak to that at this point. Or is there anyone in the room?
No, there's no one in the audience.
Okay, excellent. So can I have a motion?
Move G1A.
Okay.
Second.
Excellent. We can do both G1A and B together.
Be happy to move G1A and B.
Excellent. Thank you very much. We have a motion by Commissioner Cohen, a second by Commissioner Myers. And with that, please take a roll call vote.
Overman,
Yes.
Cohen,
Yes.
Hagan. Commissioner Hagan, Kemp,
Yes.
Myers,
Yes.
Smith,
Yes.
White.
Yes.
Motion carried 6-0.
Excellent. Thank you very much. On to staff items. Mr. Gormley, you're recognized.
Thank you. We have two remaining items. We have the staff item, and we have the applicant in for item
Oh,
E1.
that's right. We have to come back to. That's right. That's right. Do you want to take that item before your staff report?
It's the board's pleasure. Yes.
Okay. That
Item
was
E1.
E1. Is the applicant present?
Yes, the applicant is present for E1.
Okay.
So
Excellent. So where we left off.
Okay, going to E1 then. Again, for the record, Brian Grady, Development Services. E1 is PRS application 22-0850. The applicant's Ty Witherington. The subject property is located on North Dale Mabry Highway, at the corner of Lutz Lake Fern Road and Dale Mabry Highway. As noted, the request is to increase the square footage within the existing shopping plaza by 2,000 square feet to accommodate conversion of an existing 3,000 square foot bank to provide for a 5,000 square foot health practitioner's office. As part of this request for the out parcel containing the existing bank, the applicant is restricting uses to the health practitioner's office as part of this request. Staff is recommending approval of subject conditions and are available for any questions.
Excellent. Thank you very much. Is the applicant present? Has the applicant been sworn in?
I don't believe the applicant's been sworn.
My name is Roland Dove, Spring
Please
Engineering.
raise your
Wait,
right
just a moment, please. Just a moment, please. Don't start the clock. Can you please swear him in, please?
Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. Please proceed.
Roland Dove, Spring Engineering, 3014 US Highway 19, Holiday. This is a Tampa Family Health Center project, which involves converting an existing bank with drive-through lanes into a medical and dental office project. We are requesting an increase in the allowable square footage in this PD to accommodate that. It's a 2,000 square foot increase. We've read staff recommendations and conditions, and we accept those. Thank you.
Well, thank you very much. Do we have any proponent or opponent testimony to this effect?
We do not have anyone in the room nor online.
Excellent. Thank you very much. And do we have PC staff, Planning Commission staff? No.
This is a minor modification.
Oh, that's
that
right.
doesn't go
I'm
before
sorry.
the.
Doesn't require that.
Second.
Thank you. We have a motion to approve by Commissioner Smith, a second by Commissioner Kemp. Please take a roll call vote.
Overman?
Yes.
Cohen?
Yes.
Hagan? Commissioner Hagan? Kemp?
Yes.
Myers?
Yes.
Smith?
Yes.
White?
Yes.
Motion carried 6-0.
Excellent. Thank you very much. Mr. Gormley.
Commissioners, the last item on the agenda is a report regarding potential land development code and comprehensive plan amendments to further the protection of gopher tortoise habitat and significant wildlife habitat. This is a follow-up to the report that the board received on June 2nd. At that meeting, the board directed that we prepare a report on 4 potential amendments to the land development code and or comprehensive plan. The first is to require a gopher tortoise burrow survey when gopher tortoises are identified on a site. We're proposing, when a site is developed on significant wildlife habitat, a wildlife survey is required for other developments that are not mapped significant wildlife habitat, but may have conditions that would be supportive of that. We do a staff visit. What we're proposing is that if either of those identify the presence of gopher tortoises, that a burrow survey and management plan conducted by a Fish and Wildlife Commission approved representative be provided to us. We would then use that to assist with any design considerations on site if the tortoises were going to be maintained on site, or also to supplement information that's generally available to assist with any wildlife permitting process. We're also, pursuant to the board's request, would be requesting that with the Gopher Tortoise survey, there be an affirmative statement by the property owner and applicant, if different, that they have not been found to have violated any Gopher Tortoise regulations in the state of Florida. That's one amendment. The next had to do with an incentive to preserve wildlife habitat on site, preserve additional wildlife habitat. What we're suggesting is that so there's limits on the amount of site that we can require to be preserved as significant wildlife habitat. If an applicant voluntarily chooses to preserve more, we're suggesting an allowance for a lot size reduction of up to 10% on interior lots, so it wouldn't be affecting the outside borders of the project, up to a total reduction in land area that would equal the additional land area protected. So, for instance, if an additional acre of significant wildlife habitat was going to be provided, then lot size reductions could be requested that would equal to up to that acre. So the idea is making up that additional land that would be preserved that could otherwise have been impacted through reduced lot sizes internal to the project. That would be hand in hand, I'd say consistent with the, I'm going to jump to the last item, the comprehensive plan amendment, because I think these two are pretty well related, that would recognize that the preservation of gopher tortoise habitat is a specific consideration when evaluating a project and its compatibility. And what I would suggest and offer is consistent with the lot size reduction for significant wildlife habitat, that this language be not only for gopher tortoise habitat, but wildlife habitat in general. I believe that's consistent with the intent of the board and would go forward that way if the board's accepting this. The last item was to provide for increased penalties for unpermitted land alterations that involve significant wildlife habitat. And so what we're suggesting is a land development code amendment that would provide a two-prong approach to unpermitted significant wildlife habitat disturbance. The first would be that the first and primary remedy for that would be to restore the wildlife habitat. Now that may in some situations be feasible, so in others it may not. It is an involved process that is a multi-year monitoring project. There's multi-year monitoring requirements to ensure that remediation sticks. We would put those as requirements on the applicant and to be at the applicant's cost. In the event that it's determined that a site either is not suitable for remediation or is a site that would have otherwise been permitted, if exceeding the amount that we can require to be preserved, that we would establish a mitigation fee that would be payable in lieu of the reclamation if that were not possible, or for impacted land that could have been permitted, and that cost would be calibrated to the county's average cost per acre of restoring impaired significant wildlife habitat. Those are the four comp plan and land development code amendments that we're suggesting in response to the board's direction. If the board is accepting of would like us to move forward with these as presented or with any amendments to it, we'd propose to put this in the round 2 land development code amendments, which would have text coming back to the board at a workshop on August the 10th. And that concludes my report. Available for any questions or any direction the board may have.
Excellent. Thank you very much for bringing that back. Commissioner Smith, you're recognized.
Thank you. And in the interest of time and the noting the hour, I'm going to keep my remarks very brief. But I do want to thank staff for really digging into what we had asked them to do at our board meeting and working with the legal department and the development services department and figuring out exactly what kinds of things we can possibly do very creatively within the confines of what the state restricts us from being able to do. And it's quite clear that we have staff who are every bit as concerned about protecting our natural resources and our wildlife habitat as we have indicated and as we've begun this process. So if anybody has any questions or objections, I will get back into more detail of how great all of these things are. But for now, I'll just make the motion to direct staff to move forward, to bring back the Land Development Code and comp plan amendments that are summarized in this backup in the next rounds of those. And while they're at it, to see if there's an opportunity for offering any similar protections within those amendments for habitat for other listed species, burrowing owls, scrub jays, et cetera, or the significant wildlife habitat as a whole, as you mentioned with regard to the comp plan amendment.
Second.
We have a motion by Commissioner Smith, a second by Commissioner Kemp. Commissioner Kemp, you're recognized.
Thank you. And I just like to say as well, yes, it was a very thorough and comprehensive and a very great job by staff on that, but also to Commissioner Smith for championing. I've heard, for the years you've been on the commission, I think I've learned so much about gopher tortoises and how important they are to this environment and how our role in protecting them. So thank you for all your work on this. And this is going to, hopefully we will have our gopher tortoises here for many, many, many generations to come.
Thank you. And who knew we were all a bunch of tortoise fans? I've been a Maryland Terrapin forever, so I'm, so I can truly appreciate the love we have for our tortoises. But that being said, I did have a question. When we have used the reclamation cost factor, how does that correlate with the relocation cost associated with the square footage anticipated for tortoise removals or things like that?
Yeah, so Commissioner, we were very cautious about staying within our regulatory purview, and have gotten some really good, strong, and very helpful guidance from the county attorney's office to help us stay in the correct path and find ways to address these in a creative manner. We did not look at the cost of relocating the gopher tortoises themselves, as we felt that would perhaps get into the realm of regulating the animal, the species itself, as opposed to the habitat. And as you advised, there's a pretty clear delineation of that jurisdiction of regulating the animals themselves, the wildlife, is we don't have jurisdiction with that. That's with the Fish and Wildlife Commission. So we looked at the land element and not the animal element.
Oh, I already understand that.
Yes.
I'm looking at the behavioral element of human beings that are going to compare the cost of what the state will set for relocation and what the risk is of not doing that and having to assess whatever the cost is for the restoration. And if it's cheaper to take the risk and have to pay for the restoration, that will be the outcome. They will just basically take the risk and do the restoration cost if it's quite a bit less. So that is why I was curious if there's a correlation at all or if it's anywhere close, because we've given a description, but not necessarily an understanding of how that's calculated and whether it correlates at all.
And Commissioner, we can come back with that cost. I do just want to be clear that we're staying
I understand.
No,
I get
yes.
it.
Yeah, we can come back with that information at the workshop if it would be helpful.
No, I would appreciate it, because I think if it's very clear that restoration costs exceedingly more than relocation, we won't have a problem. But if there's an implication that it's less, we may still have a hesitancy of behavior that we would prefer not to see. So thank you very, very, very much for your report. And with that, we'll take a roll call vote.
Overman?
Yes.
Cohen?
Yes.
Hagan? Kemp?
Yes.
Myers?
Yes.
Smith?
Yes.
White?
Yes.
Motion carried 6-0.
Thank you very, very much. Not seeing any other items unless we have future items that we need to discuss, but I don't see any and don't hear any, so I will call the meeting adjourned at 1:15. Thank you.